Showtime.
Ding, 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 ding.
Good morning. My name is Gary Myers, and I'm the Dean of the University of Missouri School of Law. It is my great honor to welcome all of you here today on Veterans Day, a day when we recognize and honor those who've served in our military, who've served their country and who've sacrificed. And it is also today an opportunity for us to address some of the pressing issues of the day, issues that you read about regularly in the media, issues related to post-traumatic stress and military sexual trauma. As you watch the proceedings and listen today, you'll see the information streaming on the screens, which highlights to me the importance and timeliness of these issues. Now, today's symposium is sponsored by the University of Missouri Veterans Clinic, which started its operations here in January of this year, January 2014. This clinic has been already achieving important and significant results for veterans and their families, and I'm very proud of the work that Angela Drake and the students and staff that work in this clinic have been and will continue to do to help those who've served this country. Now, before we get started today, I'd like to recognize a group of people in the audience, and that would be those who are veterans of the military, active duty in any branch, reservists, or National Guard. If you would please stand or raise your hand to be recognized by our group. Thanks to all of you for your service. It is now also my honor to introduce to you the director of our Veterans Clinic, Angela Drake. Angela is the person who has single-handedly, in my view, taken on this role of helping veterans in the state of Missouri, helping with the challenges that they face. We're very proud of the work she's doing. She is the daughter of a soldier who was killed in the Vietnam War. She's an experienced practicing lawyer here in the state of Missouri for many years, and then she joined us to help operate, run, direct, and lead this wonderful clinic. And so it's my great honor to introduce Angela and to thank her for all of her work.
Thank you very much. Thank you, Dean, for the kind remarks. Of course, none of it would be possible without a dean who was willing to listen to some students, Sean Lee, Scott Apking, Chris Dunn, who approached him with the idea of having a veterans clinic. The stars aligned, and we're thrilled to be in our second semester, and we really want to help veterans. I am literally inspired every day by my students and by the people that we serve. So I couldn't have a better job, and I'm thrilled to present today our first annual symposium, which means we're probably going to have a second symposium next year. Along those lines, logistically, we're going to run this thing with military precision. We are going to get through all of our very talented, experienced speakers. So we will stay on time today. We ask that you please fill out an evaluation form at the end of the symposium so we can bring you a bigger, better symposium next year. So thank you all for being here. Thank you, students. Thank you, veterans. We so much appreciate everything. And with that, I'd like to introduce Devin Scott, who is one of our students, to introduce our first two speakers. Amy and Evan, would you like to come down, please?
Hey folks, I'm Devin Scott. I'm a 3L here at Mizzou Law. Like she said, I'm involved in the clinic right now, and it's my distinct honor this morning to introduce you to Amy Odom, who's the Director of Litigation for the National Veterans Legal Services Program, and Major Evan Simone, who is prosecuting attorney with the Office of Chief Prosecutor of Military Commissions.
So good morning. So a little bit of experience and background actually presenting, prosecuting, and litigating a claim for PTSD or another mental health disability based on military sexual trauma. So I'm going to start this morning by walking you through how to present a claim, what you need in order to prove entitlement to VA compensation or disability compensation for a claim based on military sexual trauma. It's going to be a little dry because we're going to go through the elements like you guys are in a classroom, but I promise it'll pay off because at the end I have some real life experience or examples where we'll get to see how it all kind of plays out.
Amy, I'm sorry, let's get some help here. Who can handle this PowerPoint? Kristen, you want a clicker?
Sure.
First symposium, we've got a little rough spot.
Okay.
Thank you, Chris. You've got it? All right. So you should be able to click and,
Okay.
there we go.
Okay. So I'm going to use the term service connection a lot, and it's kind of a term of art in VA benefits law, and it means that a disability has been found to be related to service, whether it was incurred in service, caused by something that happened in service, or was a pre-existing disability that was aggravated by service. Oh, sorry guys. So, and one's entitlement to VA disability benefits derived from a statute, and so there's the language from the statute there. Congress has provided that VA shall pay, not may, it's not discretionary, shall pay to any veteran disabled in service, disabled by something that happened in service compensation. So when we're talking about a claim for service connection based on military sexual trauma, we're talking about getting VA disability compensation. So something that kind of blew my mind when I first started out in this field is how broad this is. You might think that, well, you know, in order to get VA disability compensation, it would have to be something that was directly related to combat or even something that was directly related to your military duties, and that's not what it is. The statute is actually very, very broad. It's anything that happened during service, whether it was related to military duties or not. So somebody who had an accident on a ski vacation while active duty in the military would be entitled to VA benefits for any disability arising from that accident, even though it had nothing to do with military duties. So that was something that kind of struck me when I first started, how broad everything is. So now we get to the elements. So in order to prove entitlement to these benefits, there are three essential elements. First, that you have a current disability. Second, that there was an in-service injury or disease. And third, that there's some sort of causal relationship or nexus between the in-service disability the current disability and the in-service incident. And that third element is where most claims fail, because in most cases it has to be medical evidence, and that's very difficult to come by for a lot of veterans. So there are really two, and for purposes of our discussion, there are really two regulations that control here. And the first one is 38 CFR 3.303, which is kind of like the general service connection regulation. And so the first subsection says that you can get service connection for any disease or injury that was incurred in service. And we call that direct service connection. So what that means is that if a veteran was first diagnosed with PTSD or depression or something like that in service, and it's in the service medical records, then you would get service connection for mental health disability incurred in service, regardless of what the cause was, whether it was MST or anything else. It doesn't matter as long as it was diagnosed in service. And this will be important because we'll talk about a little bit later how difficult it can be to prove an actual personal assault in service. So then in the same regulation, we have another provision that says if something is diagnosed after service, so there's no indication that it was diagnosed in service or started in service, you can still get service connection so long as all of the evidence shows that it was incurred in or caused by some injury in service. So that's when that medical nexus evidence comes into play and becomes really important. And that's known as delayed direct service connection. So that means if a veteran, there's no evidence that there were even complaints of a mental health disability in service, which is pretty common, right? Because, I mean, just like you and I, soldiers don't necessarily go running to the infirmary every time they feel a little blue, right? So often there won't be any documentation at all of any symptoms or treatment of a mental health disability in service. And then years later, and sometimes I've had cases where it's decades later, the veteran is diagnosed with a mental health disability. And then you can still get service connection, even though it's been so many years, but you need to have the medical evidence linking the reported symptoms in service to the current disability. And so here's the real bugger. This is the regulation that deals specifically with PTSD. So these are special rules for PTSD claims. And it makes it harder to prove entitlement to these benefits if you have a diagnosis of PTSD, because it requires a diagnosis that conforms with the Diagnostic and Statistical Manual of Mental Disorders, which we call the DSM. Dr. O'Neill will be talking a little bit more about that later today. And credible supporting evidence of the in-service stressor. So we're going to get into this a little bit more, but the difference between these special rules for PTSD and the regulations that we just talked about, the general regulations about direct service connection and delayed direct service connection, is that a veteran statement alone can be proof of the in-service stressor under the other regulations, but not for PTSD. For PTSD, you have to have supporting evidence, which can be extremely difficult, and we'll get into that a little bit later. And then you have to have the medical evidence of the link between the proven in-service stressor and the diagnosis of PTSD. So in the context of military sexual assault, this can be very difficult to get this credible supporting evidence, because often it's not going to be documented in the records, right? Because sexual trauma often goes unreported. So the VA said, well, if you don't have to have it documented in the records, and this is what this other stuff can qualify as the credible supporting evidence. So there are police records, which again would indicate that it's been reported, right? So that's not very helpful. Medical records, which again would indicate that the veteran sought treatment for any injuries that occurred during the assault, which again is not likely to happen. STD and pregnancy tests, statements from family members and friends, and that's a pretty important resource for veterans and advocates who are trying to prove an in-service MST. And evidence of behavioral changes, and this is usually where you are able to satisfy the regulation, because these things will be documented in the records in a lot of cases. It won't indicate that it's because of a sexual assault, of course, because a sexual assault is likely not going to be reported. But you might see these things. There might be an increase in drug or alcohol use, a request for a transfer, unexplained economic changes, personality changes, and deterioration of work performance would definitely be documented in the veteran's performance reports and his or her personnel records. And you can prove these other things, the personality changes, the drug and alcohol use, you can prove that with the statements from the friends and the family. So that's helpful. And we'll get into that a little bit more. I think I'm having a problem. Oh, here we go. Never mind. So let's go through it element by element in the context of an MST claim. So you have to have a medical diagnosis of a current mental health disability that conforms with the DSM-V. So your veteran reporting symptoms of depression isn't going to be sufficient unless he or she is a trained psychologist or a psychiatrist or mental health counselor. And the regulations are clear that the diagnosis must conform to the DSM-V. And that's a way for VA to make sure that there's some uniformity in how mental health disabilities are diagnosed. And I think that's pretty fair. These are the old slides. But don't pay attention to this. Dr. O'Neill, who is qualified, is going to talk more about these diagnoses. But just to get an idea of what the diagnoses might be, they might be major depressive disorder, panic disorder, or something like that, or PTSD. We're going to skip that. So I kind of touched on this a little bit earlier, but it's really important what diagnosis is actually assigned, because that's going to determine how you're going to prove the in-service stressor, right? Because if it's anything other than PTSD, then you go to 3.303, which is the general service connection regulation, and you can prove the stressor by the veteran's statement alone of what happened. But if you have PTSD, you got to go to 3.304F5, and you have to have that credible supporting evidence. So the best case and the easiest case from the point of view of the veteran and the advocate is when there's an in-service diagnosis, right? So for PTSD, the regulation says you don't need the credible supporting evidence of the stressor. If there's an in-service diagnosis, the statement alone is fine. So that's a little bit easier. And then for 3.303, if it's anything else like major depressive disorder, anxiety disorder, then the different rules apply and you don't need any supporting evidence. But that doesn't necessarily mean if there's a diagnosis of PTSD in service and a current diagnosis of PTSD that you get service connection, that the claim is proven. You have to also still satisfy that third element, the medical link between the current diagnosis and the in-service diagnosis. So, but the world's not perfect, right? So you hardly ever see a claim, especially when at the higher levels of the adjudicatory system where I practice, you would hardly ever see a claim that got that far through the system where there's an in-service diagnosis. In all the cases, there's no in-service diagnosis, there's no in-service treatment, there's no in-service complaints with symptoms. So you have to actually prove that the military sexual trauma occurred. And so that's when it gets a little bit more difficult. So an important thing to keep in mind is that Congress has set up the VA benefit system to be very pro-claimant. And there's this benefit of the doubt rule that's set forth in statute that says that if the evidence is evenly balanced, the benefit of the doubt goes to the veteran. So it's a pretty liberal standard. It's pretty claimant friendly, but it's not like a criminal defendant, right? So it's not like the VA has to prove beyond a reasonable doubt that something didn't happen to the claimant. The claimant still carries the burden of coming forth with the evidence that's required under the statutes and the regulations. So here we get into, again, where it's easier to prove an in-service military sexual trauma if the diagnosis isn't PTSD. And that's true for any situation, for a combat veteran or for a veteran who was exposed to hostile military forces. It's much easier to prove the case and entitlements benefits if the diagnosis isn't PTSD. And that's just how the regulations have been written, and there's probably a reason for it, but I could talk like hours and hours about it. So if you want to know, give me an email. But for our purposes, let's just believe me that's what it is. So, but if we're talking about anything other than PTSD, the case law is really in the veteran's favor. The courts have made clear that the VA can't reject a veteran's report about what happened in service simply because it's not documented, unless, and this goes to pretty general rules of evidence, unless it would be reasonably expected to be documented in the records. It's kind of like the business records exception. It's kind of adopted, the rule is adopted a little bit from that. And then in AZ versus Shinseki, the Federal Circuit last year issued this landmark case dealing with military sexual trauma specifically, and said that, because military sexual trauma or sexual trauma in any context is so underreported and oftentimes is not reported and the veteran doesn't report it, then you can't reasonably expect that you would find documentation of a report in the service records, which means you can't treat the absence of that documentation as substantive negative evidence against the veteran's claim. So what that means is if all you have in the claims file is your veteran's consistent statements about what happened, and there's nothing that contradicts those statements, and the VA has to accept them as credible. So this is what happens at court, right? But what happens at court and what happens at the agency are usually two different things. So while I don't believe that corroborative evidence is legally required to prove an MST when the diagnosis is not PTSD, when you're developing a claim and prosecuting a claim before the agency, it's always best to have corroborative evidence. So what if we have a diagnosis of PTSD? Well, then the statement alone can't prove MST because the regulation requires the credible supporting evidence. So we went a little bit through the regulation, what the examples of the credible supporting evidence are, including the statements from friends and family and the evidence of behavioral changes and all that. And the courts have held that VA examiners after the fact, or any medical examiners after the fact opinion that the person's PTSD is related to a history of sexual trauma is also credible supporting evidence. And that's kind of a newer development. So what an examiner might say, you might see, is that the symptoms are consistent with somebody who had suffered a sexual trauma, and that would be corroborative evidence. And then, of course, we have AZ again, which says that suppose you have this medical opinion where the doctor says that the symptoms suffered by the veteran are consistent with sexual trauma, and you don't have anything inconsistent with the veteran's statements of what happened in service, then AZ says you can't treat just the absence of the report in contemporaneous in the service medical records as substantive negative evidence that can be weighed against the medical opinion and the veteran's statements. Does that make sense? All right, good. So now let's get to element 3. So in your ideal perfect case, you've got the veteran has consistent and credible statements about what happened in service. There's some evidence that fits the definition of credible supporting evidence in under 3.304 under the PTSD reg. And then you have a doctor who says, yes, there's a DSM-V diagnosis of PTSD, and it's related to this history of sexual trauma that occurred in the service. But that's not what always happens, and especially if the case gets to where I am in the adjudicatory system, that has not happened. The hard cases are when the veteran has suffered multiple trauma. So some things that I've seen in my own practice that are considered trauma and stressors that are considered by the examiner are childhood physical and sexual abuse, post-service domestic abuse, and other current stressors, just regular life stressors to include, a death in the family or other family situations, financial situations, comorbid, which means coexisting personality disorders, which are not disabilities for VA purposes, and coexisting medical disabilities, which can oftentimes affect somebody's mental health as well. So what I have seen is that an examiner will say, and let me just back up. So VA has a duty to assist a veteran in obtaining evidence to substantiate his or her claim. And when certain evidentiary thresholds are met, it includes a duty to provide the veteran with a VA medical examination and opinion, right? Because you can't prove your claim in most cases without medical nexus evidence. So VA has to help the veteran in most cases get that. So when I see this, when I say the examiner may say this or that, I'm talking about a VA examiner who has examined and provided an opinion to the decision makers as a result of the statutory duty to assist the veteran. And sometimes they're messy. Like, you might see the examiner says that a disability was caused by, or the PTSD or the depression was caused by pre-service stressors, but that the disability was exacerbated or aggravated by military sexual trauma. And what's really important to figure out in those cases is, what does the examiner mean by aggravated? Because there are different rules that will apply depending on what that examiner meant. So if the examiner is saying that the military sexual trauma contributed in any way to the development of the disability, then the VA should grant service connection for the disability. Again, we're going to go back to this benefit of the doubt rule. So the courts have interpreted that rule to say that if you can't separate the effects of a service-connected disability from a non-service-connected disability, then the benefit of the doubt goes to the veteran, and the veteran gets compensated for the entire disability. So that should apply equally here, right? If the examiner can't say, well, this veteran has major depressive disorder, and 50% was caused by pre and post-service stressors, and 50% was caused by MST, well then there's nothing to portion out and the whole thing should go to the veteran. I don't even know if that's possible. I'm not a trained doctor and I've never seen it, but suppose that an examiner did say that, then that would be something that an advocate would have to consider. And if the examiner is saying that the veteran already had a mental health disability at the time of the MST, and that mental health disability stemmed from the pre-service stressors, well then a whole different set of veteran-friendly rules comes into play. There's an idea called the presumption of soundness, that when a veteran is examined, enrolled, and accepted for service, he or she is presumed to be free of any defects unless those defects are noted in the entrance examination. And I mean, it's pretty rare, I would think, that somebody would be examined for service and report a diagnosis of PTSD and be accepted for service anyway. So I've never seen a mental health defect listed on an examination or an entrance examination. So if it's not listed in the entrance examination, then there's a rebuttable presumption of soundness. And what does rebuttable mean? It means that the VA can rebut it. But the standard for rebutting it is extremely high, because that's how much faith we put in to the idea that a veteran is sound when accepted for duty, except for defects that are noted. So the VA has to rebut that presumption by clear and unmistakable evidence, which is a very, very high burden. It means that the evidence is undebatable. And they have to not only show that it actually pre-existed, but also that it was not aggravated by service. So think about that and how difficult that would be to show that it was clearly and unmistakably not aggravated. That means that the VA can't just say, well, there's no evidence that it was aggravated. That's not evidence of not aggravation, right? That's just a lack of evidence. And so if that's what the VA has before it, then the presumption is not rebutted, even if there is clear and unmistakable evidence that it actually did pre-exist. So it's pretty difficult for the VA to rebut that presumption. Another thing that I've seen is that if there are post-service stressors, the examiner will say, the current disability is related to all these post-service stressors and not the in-service stressor. And the important thing there is that the examiner isn't allowed to just give the decision makers a conclusory statement. The examiner has to explain how he or she reached that conclusion. I mean, The explanation doesn't have to be 4 paragraphs and 20 pages long, but there has to be something that the decision maker can see on the report that will give the examiner or the decision maker some idea of how the examiner reached that conclusion. So that means that if you have evidence of symptoms, even the veterans now, after the fact report of symptoms that were present prior to those stressors, then the examiner has to explain why those symptoms weren't part of the now diagnosed disability. And since they were present prior to the post-service stressors, then it wouldn't make sense, right, to say that it was only caused by the post-service stressors. So those are the kinds of things that advocates need to be aware of and look at. Okay, so now we get to the good part, the examples. So these are real cases that I personally have litigated. And these kind of show how they all these regulations and concepts play out. So Mr. L was an Air Force vet who was wrongly accused of larceny in like 1958 and was put in the stockade while he was awaiting trial, or his court-martial, and then he had his court-martial and was found not guilty. And years later, he reported that he was sexually assaulted on several occasions during his incarceration. And what's pretty common with older veterans is that his service records have been destroyed in a fire at the National Personnel Records Center in 1973. So we had no medical records to show if he had any symptoms in service, if he had sought treatment for any contusions or bruises or cuts that would corroborate his story that he was assaulted during his incarceration. But his post-service treatment records showed various diagnoses, including PTSD. And his family members submitted statement talking about longstanding substance abuse after service and employment difficulties after service, and that goes to the behavioral changes, right? If they all occurred after service, it means they occurred after the alleged stressor, so this counts as corroborating, credible supporting evidence under the PTSD reg. And then a VA examiner diagnosed PTSD and linked it to military sexual trauma. So the VA denies the claim, finding that the lay evidence alone can't establish that the sexual trauma actually occurred under the PTSD reg, that it wasn't sufficient credible supporting evidence, and that the VA examiner's opinion isn't good evidence either because it's based on an inaccurate factual premise that this guy was actually assaulted in service, which the VA has found to not happen. So we took it to court, and the court actually reversed VA's decision, ordered VA to pay this guy benefits. It found, of course, that the lay evidence is specifically contemplated under the regulation, which specifically says statements from family members is credible supporting evidence. And the evidence also established behavioral changes, which is also specifically identified by the regulation as credible supporting evidence. And that the post-service treatment records in the VA examiner's opinion were also contemplated under that reg as credible supporting evidence. So all three elements, the current disability, in-service incident, and medical nexus between the in-service incident and the current disability had been established by the record, and the VA was clearly erroneous in denying. Okay. So I probably only have time for this one and one more, but this was another case that was pretty sad. So Mr. H had been sexually assaulted by a fellow service member several times in the 1960s. And in this case, we did have the service records. And sure enough, they did document behavioral changes. They documented an increase in substance abuse. They documented complaints of anxiety and depression, and 2 incidents of non-judicial punishment for like leaving his work, his duty station, and stuff like that. And then this guy filed a claim in 1985, and a VA examiner even in 1985 said this guy has PTSD that's consistent with personal assault. But the VA denied the claim in 1985, and what's interesting about that is in 1985 there was no judicial review of VA decisions at all. The court that I practiced in front of wasn't created until 1989, and it has exclusive jurisdiction over VA decisions, so he couldn't have appealed this if he wanted to. So we've got all this good evidence, but and the VA asked the Joint Services Research and Record Center to verify the attack, right? Like in the unit records, like that's gonna happen, right? So of course the JSRC says we can't verify this. And so the VA denies the claim, saying there's no credible supporting evidence that this trauma actually occurred because the JSRC was unable to verify it. So we took it to court, and we did not get a reversal in this case because this was before AZ, and it was the court issued a non-precedential single judge decision where the judge said the court is only allowed to reverse if the finding is clearly erroneous, which means there has to be a finding that is sufficient under the reg and talks about all the evidence. So this judge said, I can't reverse because the board didn't make sufficient findings here, because it's possible that the fact that the vet didn't report the trauma when he went and sought, care for his anxiety symptoms and depression symptoms is substantive negative evidence that can be weighed against the claim. Now that wouldn't fly after AZ, this was before AZ, but that just goes to show, how difficult these claims can be. So with that, I think I unfortunately don't have the time for but he did finally get his service connection after 26 years, which also shows how difficult these claims can be. So I'm running out of time here, but thank you for your attention. Sorry I couldn't get to the rest of them, and
I was going to body tap
I know.
because we're going to stay on task. Thank you, Amy. Two things that I found really interesting. Military sexual trauma, her two real-life examples where males were affected. Everybody thinks that only women are affected by military sexual trauma, and that is not true. Unfortunately, males in the military are affected. For our students, listen to this duty to assist idea. VA is supposed to help the veteran prove their claim. As you can see in the examples, that duty to assist doesn't always really help the veteran, and you need a good lawyer like Amy to tell the court where they went wrong. So now we'll have Major Simone with his presentation. And we've got some students who have to go to class, so I apologize for that.
Thank you so much, Professor Drake. I want to thank you all for taking the time on this very special day to attend this symposium. And I want to thank Professor Drake so much for assembling this group of leaders, experts, and advocates for our veterans and active duty service members who have very significant needs. So I really appreciate the opportunity to be here. Today I'm speaking in an entirely personal capacity. I do not represent the positions of the Department of Defense, Department of the Army, Department of Veterans Affairs. They don't endorse my positions, but perhaps sometime in the future they hopefully will. That's my hope. Today I'll be discussing two things. The first is going to build on Amy's wonderful introduction to this issue of cumulative trauma, that is, multiple traumatic events occurring over the course of the veteran's life. And we're going to pay specific attention to pre-service childhood sexual assault and pre-service adult sexual assault, because these are hidden issues normally in the discussion of military sexual trauma claims adjudication, but they are so vital to understand because they represent a very significant number of denials, at least at the regional office level. And the way that I learned about this was by working with my colleague, David Trasky. And for over a year, what we did is we looked at 2,170 Board of Veterans Appeals decisions over the course of a 10-year time span. And all we wanted to do really was look at trends. Where were claimants successful in MST cases, and what kind of obstacles did they face? And based on our analysis, cumulative trauma was an issue we thought was important to address, and I'll be talking about that briefly. The second thing I want to talk about, though, is the impact of exposure of the attorney to the client's trauma. and the traumatic material that underlies these cases, especially in cumulative trauma cases where you're interacting with the client's past victimization and the military victimization. And there are inevitable human consequences and actually health risks from this secondary trauma that attorneys experience, secondary traumatic stress. So I want to discuss that in terms of the manner in which legal professionals are exposed to STS, symptoms of STS exposure, preferably what we can do to identify these symptoms and mitigate them, and finally, a piece on the Veterans Council as the first responder. And the reality here is twofold. We are, in essence, oftentimes, because we don't have the luxury of having a mental health professional there with us while we're counseling these clients, while we're deciding on legal courses of action, we don't have the benefit of mental health guidance, and we have to deal with the aftermath of military sexual trauma, post-traumatic stress disorder, other mental health conditions, and it puts the attorney in a very challenging place because you have to respond to stress triggers that are inherent in the adjudication process. How do we do that? That's what I call the attorney as first responder perspective. But the other important factor here is that because of the nature of the underlying material in these cases, we are also trauma workers. And there are significant risks that come with that. And so that's what I want to talk about today for the majority of the presentation. It's important here for one moment to think about how the law is so resistant to addressing emotional issues, right? Because there's a premium for lawyers to separate the objective from the subjective, right? To be able to take an objective analysis of the legal issues and not be clouded by emotion. And so we don't have enough discussions about what we can do when we are affected, and very commonly the answer is, well, the good lawyer is going to detach himself or herself from emotions while dealing with the case. And how do you do that? How exactly do you do that? And it's very difficult. And there's this idea that when we're wearing the lawyer hat, we don't want to step into the area of mental health. We're not trained mental health clinicians, and that's true. We are not social workers. We're not psychologists. Our goal is not to help improve the client's entire life and every issue they're having. And if that was, then our effectiveness as attorneys, if the client expects us to solve all their life problems, it actually diminishes the value of our legal counsel. So there is, in fact, a boundary. However, that doesn't mean that we can avoid the impact of psychological influences, and quite frankly, oftentimes we need to incorporate some of these tools into our counseling in order to meet our legal obligations. So rather than just thinking in terms of the law hat and now the psychology hat, I'd like to adopt the perspective of lawyering informed by psychology, and you'll see some of that in what I'm about to talk about. Now, cumulative trauma. I want to start with an example of the case of Mary. And Mary has a lot of life traumas. We're going to talk about them in a moment. But Mary is representative of many of the cases we saw in these BVA opinions involving denials of MST benefits. And I want you to think for a moment about the fact that research shows a substantial portion of our recruits into the military have prior childhood sexual assault and prior abuse histories. In fact, there are differences, right, in sample sizes. Some of these research projects have involved treatment-seeking veterans. There are different definitions of what childhood sexual assault is. But when we get beyond these issues of generalizability, it's pretty clear from the research that there are more survivors with trauma histories, sexual trauma histories in the military than there are in the civilian world. And we have statistics I've cited that they estimate that between 10 and 17% more women veterans have been assaulted during their childhood than civilian women in the general population, and that at least a third of female veterans has an abuse history. And those are just some poignant examples. So the fact that this is an issue that comes up often is something we should take note of, okay? And it kind of makes sense when you think about it. You see that the military offers something to survivors of abuse in an abusive environment. Joining the military allows them to be transported away from the source of the trauma. It gives them job skills, gives them income, gives them a new family to work with that camaraderie, and gives them a way to be self-sustaining in the future. So oftentimes the military is called an escape for someone who has one of these traumatic environments, and that could explain why we see so many of these issues when you have MST survivors. And we should note that the research repeatedly shows that someone who has been sexually assaulted is at great risk of re-victimization, right? So when you have someone with an abuse history, there are chances of re-victimization. So with that in mind, I'd like to do one small exercise, and we're good on time. Mary, I want you to think about these different events. Mary, between ages of 6 and 9, 2 cousins over the course of weekends during a period of years raped her repeatedly. When that occurred, this came to the attention of law enforcement. There was actually a prosecution, and the cousins were acquitted. And one contributing factor was hours of cross-examination that she had to endure. She feared for her life that her cousins would come after her after the acquittal. And beyond that, and this is at the age of 12, beyond that, it split the family apart, and some of her family members actually accused her of fabricating the story to get attention. Awful things occurring. Okay, so after that, she found a boyfriend. She got pregnant at age 16. They're both driving in a car. There's a horrible accident. He dies. Shortly after that, she has a miscarriage. Things were getting better, and now she was back in a situation where she feared for herself once more. Between ages of 16 and 17, she leaves her home. She lives with friends and is homeless on an intermittent basis. But she gets her GED, and at age 19, she joins the Marine Corps. But shortly after her enlistment and moving on to her unit, during time in CQ duty, charge of quarters, she's pushed into a broom closet by a senior non-commissioned officer who attempts to rape her. Another Marine hears her muffled cries, stops it from happening, and shortly after that, she starts experiencing very severe symptoms of PTSD. Things move on. She's getting notes that are anonymous from other members of the unit saying, "You're destroying a great Marine's career." She doesn't want to go back to work in the same environment. They talk about the potential of charges against her. She leaves the military, and now she's applying for benefits, and she has this history. I want you to think about all of these events. And what I've done is, if I could get Matt to help me, and anyone else, we have a number of cards. These cards right here. And if you have them, I just want you to take a second and think about these different events experienced by Mary over the course of her life. And between 1 and 10, I'd like you to rate what your impression is of the impact of these individual events on her current PTSD symptoms, just to get a sense of just our thoughts on what is significant here and what degree of significance. Just take a few seconds to do that. As soon as you're done, you could pass it up, and I want to take a look at some of our examples.
On a scale of 1 to 10?
1 to 10. 10 being the most severe, 1 being the least. Matt, if you could be my witness for a moment, come up here. Also, if you could help me collect some of them if people, if you're done, please hold up your hand and okay, great. We'll collect those too. Thank you so much. And if you could just, let's take a look together. So here's an example, and I'm not concocting this. This is from our own audience, and I'm not saying anyone's right or wrong either. Abuse by cousins, 10 on this one. The very next slide, what is it?
Legal,
No.
oh, I'm sorry, abuse by 10, or abuse by cousins 5.
So we have one person saying it's a 10 magnitude for the cousins, one saying it's a 5, a 9 just on the first one. You've got the MST listed as a 10 on a number of them, but here I see an 8. I see one rating abuse by the cousins at an 8, and then the assault by the sergeant as a 6. The legal issues, some of these 7 and 8. In this one, the legal issues rated higher than the military sexual trauma, okay? So we have a variety of answers here, and again, none of them really are exactly the same. We've got MST as a 5 in this one, and that's the point, and I'd encourage you just to look at these later. This is such a difficult issue to deal with. It reflects the problem faced by juries when they're asked to discuss, to come up with damages, assessment of damages in cases for torts like intentional infliction of emotional distress for sexual assault. And oftentimes it's the case that the juries are unable to apportion those damages because you have this interaction of trauma, and there's no real instructions on how to do that. And so defendants in that environment often do something which is described here in a Court of Federal Claims case called Elk versus the United States. Elk was a recruit who, over a course of years, was propositioned by a recruiter. Eventually, he drives her to a secluded area under the pretense of doing something related to entering the military and attempts to rape her. The expert in that case who evaluated the case opined that this really was not significant because he didn't actually there wasn't penetration, there was not a fully completed rape, it was more of a misunderstanding, and other factors in her past, like a friend's suicide attempt, the death of a close family friend, and a miscarriage she experienced, those factors were responsible for her current symptoms, and clearly they outweighed any impact of the recruiter's assault. And the Court of Federal Claims in this 2009 opinion condemned that reasoning and talked about the fact that it's just a tactic, and it's an empty tactic to just merely toss out a litany of stressors that might possibly have contributed to the survivor's mental state at a given time without connecting them. And it's really not that hard to find stressors in people's backgrounds, right? This is the social readjustment rating scale, and it talks about the impact of various common life events that could potentially affect someone and create a mental health condition. So if you look hard enough, and that's why it's a tactic, you might find various things to point to say, well, this outweighs the current claimed stressor. The sad thing is, the BVA opinions that we examined that denied claims on the basis of cumulative trauma very much reflected that standard tactic that they condemned in Elk. And in the opinions we looked at, we were seeing that there's a lot of discretion here in the way people are assigning weights. The evaluators, the compensation and pension evaluators, the clinicians, the adjudicators, and you start to see evidence of common rape myths getting infused into the analysis. You start to see the bias. Common things. You've got years of child abuse compared to a one-time confirmed rape in service, and you're saying, oh, that clearly outweighed it. That's what's responsible for the current symptoms. You've got adjudicators saying, well, this isn't a typical rape-type event, and that's what we're looking for here. You've got talking about date rapes, near rapes, degree of severity, and you've got just different factors that reveal the presence of just empty analysis similar to what's happening in the realm of litigation over torts. So, and especially the attempts when it's non-penetrative and when it's harassment involved, they look at anything that was physical or sexual and say that that was responsible. And you know, it's important to recognize, again, I want to direct you to Amy's analysis where this shouldn't be an issue of secondary service connection or aggravation if it's MST, right? You're talking about directly, you know, something directly caused during the course of military service, so it shouldn't even become an issue of comparing other types of events. We talked about the presumption of soundness and these issues, but the problem is somehow, and it's largely, I think, because of the skepticism over mental health conditions, this will oftentimes infuse its way into the analysis, and you should be prepared to counter it and understand the dynamics of this as a potential obstacle. Now, there could be cases where, let's say, and again, it's rare, but let's say you do have a prior condition noted at the time of entry. I will say that there's a lot of research showing that people who've been traumatized in the past have a lower threshold and are more susceptible to operational stresses of military service, including combat. And because of that, there have been various recommendations to explore past trauma at the time of entry to be aware of that. It ties into resilience, it ties into a lot of these programs that are currently in place. So this issue of exploring past traumas is becoming more prominent. But if you in fact do have a case where there is a legitimate reason to make a comparison, one thing I would suggest is be aware of Professor Stein's analysis that aggravation just doesn't mean, oh, the injury got worse, the symptoms got worse. You can have different forms and manifestations of aggravation. Beyond that, I think it's also important to consider two other factors. Dr. Mick Hunter talks about the fact that especially for a survivor of childhood sexual assault, military trauma nearly mirrors the childhood sexual assault in at least 10 different ways. Important to consider, especially if you're thinking about something with the magnitude to activate a previously latent condition or reactivate one. You have aspects of this, if you have an abuse of authority or someone who outranked the survivor, that definitely could be a factor there. It's also important to recognize other research which demonstrates that MST has its own independent traumatizing value, separate from the trauma that someone might have suffered if they had experienced childhood sexual assault or adult sexual assault. And there's about 4 or 5 specific environmental factors to think about that make military sexual trauma even more aggravating, even more damaging, let's say. The perpetrator's ease of access to weapons, the inability to remove oneself from the environment, you have betrayal of loyalty when it's a fellow service member who is the perpetrator. Military service is very stressful just because of what they call operational stresses and the demands and restrictions and requirements. Finally, you have a very short period of time that people serve in the military on average. It's not 20 years that the normal veteran serves, right? We're talking about a short span of years. And in that short span of years, it's a tremendous cross-cultural transition that every person, every veteran undergoes. To be sexually assaulted with all these other factors in that concentrated amount of time is something that leads to greater damage, greater symptoms. Definitely something to keep in mind. Now, we wrote an article in the Columbia Journal of Gender and Law. I have off prints outside for you. It's also available on the website. I encourage you to read it and would like you to think about cumulative trauma as part of the arsenal of issues that you might encounter in these cases and should be prepared for. But I also now think it's important. Let's revisit Mary's history to make a bridge to the second issue of secondary traumatic stress and its impact on an attorney. Think about Mary's experience, and now she's involved in attempting to wage a second battle to obtain benefits for her military sexual trauma. And we talked about all of these pro-veteran attributes of the adjudication process, right? Benefit of the doubt rule, all of these things, but unfortunately, in these cases, because of the nature of these inquiries, it's often a second battle, and oftentimes it resembles an adversarial process. And that can have detrimental effects on someone who's been traumatized. Importantly, when we think about Mary, she made journal entries when this was going on, but she can't even look at them. And even though her friend took photographs of bruises she had based on that sergeant's assault, she can't even tolerate the thought of looking at those photographs. And oftentimes she often thinks, well, maybe my family members are right. At the age of 6 or 8, I may have led on my cousins. Maybe it was all my fault. So you have issues here that are going to affect your interactions with Mary if you're representing Mary, right? And again, this is the first responder perspective. One of the things I'd like to talk about just for a moment is the fact that there's recognition that professionals who deal with victims of any type of trauma are at risk of secondary traumatic stress. But while people experience various types of traumas in their lifetimes, like natural disasters, the death of family members, medical illnesses that may be very destructive, when the trauma involves criminal victimization, it doesn't matter what professional we're talking about, whether it's your mental health clinician, your police officer, or your attorney. Those types of trauma have a greater likelihood of traumatizing indirectly the attorney or the professional, right? And they say it's something about victimization that's intentional that kind of makes you feel less safe, right? If this could happen to someone, it could happen to me, it could happen to my wife, it could happen to my child, right? So criminal victimization, and especially sexual victimization, has greater potential to affect your professional helpers. It's important to think about this area of traumatology. Shortly after the introduction of the PTSD criteria, the diagnostic criteria in the 3rd edition of the DSM in 1980, this is when there was a big interest in, what are the effects of stress on people? And this is where you really had this concern that, a constant exposure to people who have traumatic situations, that puts professionals at risk as well. The helper, what can they do for the helper? And so it's important to recognize what secondary traumatic stress is. Perhaps we should start by recognizing secondary traumatic stress isn't a diagnosis. It's kind of like MST. MST is not a diagnosis, but it's a process. It's a manner in which you can be harmed to a degree where you have a diagnosable condition, right? So STS can do that. And one of the clearest examples, and I know we're going to have some conversation about the Diagnostic and Statistical Manual, the 5th edition, but it's important to look at some of the comments there regarding acceptable causes for PTSD, which includes experiencing repeated or extreme exposure to adverse details of traumatic events. And an example cited is a first responder, potentially a police officer, who repeatedly is exposed to the details of child abuse. So there's a recognition that indirectly exposure to someone's trauma can traumatize you. And that's important to keep in mind. And there's a lot of terminology here, right? Secondary traumatic stress has different components. Again, we're talking about different methods for acquiring these types of symptoms, but they all lead to the same end result. You may have heard of countertransference, and that's just this idea that it's the sum of all of the helper's reaction to the client and what the client is bringing up during the course of professional interactions. You have compassion fatigue. That's more the issue of the helper feeling unable to help someone in need, called the cost of caring. You have vicarious traumatization. And I stress this one because you don't even have to have a direct interaction with the person to experience it. One of the best examples, and in military justice, I can give you tons of examples of this, being forced to watch child pornography in preparation for a case. You don't have to know the victim, you don't have to be there, but that can change your world, and not for the better. And then you have some people who like to say that secondary traumatic stress, well, that's the same thing as burnout. You see all these articles, burnout for judges, burnout for attorneys. Burnout is too broad of a term. Burnout deals with the perception of someone that they're not being recognized for the work they do. And beyond that, they're fatigued, they're tired, they don't have any more energy to continue. Sure, STS can contribute to burnout, but burnout does not require a traumatic exposure, and that's why it's over-inclusive to just say STS, well, that's the same thing as burnout. But again, it's important to keep in mind that these are methods for acquiring symptoms. You know, the best example I can give you to really situate this is a study conducted by Janet Alexander in 1989. Janet Alexander recruited 5 nursing professors. Each of them had over 10 years of experience as nurses, and a number of them, dealt directly with sexual assault survivors. And what she did is she said, I'm going to give you narratives of victims of rape. And what I want you to do is spend a couple hours each day coding these narratives for content. And she took 3 months to do that. And at the conclusion of those 3 months, all 5 of these experienced nursing professors with all this experience began experiencing much the same symptoms as the victims that they were reading about. So whereas you had, blame of the victim, right? So you have the victim blaming himself or herself. You have the coder blaming the victim. You've got the coder starting to avoid going places where she thinks she might be assaulted, just like the victims. And so this example shows you that you don't even have to have a relationship. You could just be reading about it, and it can affect you. And when you start looking at just general descriptions of secondary traumatic symptoms, they almost identically mirror PTSD symptoms. And then you look at helper-specific issues and you start to see things like dread of working with your client that you're supposed to be helping could be one of these factors. Looking at the world in terms of victims and perpetrators, and that's all you start to see. Loss of hope, depression, just factors here. And you have a recurring intrusive imagery of the victim's experience as described to you that you are now experiencing. And then there's a way to look at it in terms of markers of secondary traumatic stress, like a loss of spiritual affiliation. You start questioning formerly held opinions. Sometimes maybe the question, where was God when all of this was happening to this survivor? And that starts to make you question your own religious convictions. And you have social markers where you start to mistrust people that you deal with in a social environment. So this can also be a way to start realizing the effects of secondary traumatic stress on you, the helper. This is Stephen Benjes, a mental health professional. He describes the example of just watching a child forensic sexual interview that was recorded. Didn't see the actual abuse occurring, but heard the child talking about what happened to the child. It's mentioned in the article I wrote on sex crimes litigation is hazardous duty. I've also included that article for you outside. I'm going to spare you the details, but listen to him saying, just from hearing the child talk about those events, he was, for 9 years, he was repeatedly tortured by this, really. And it had a physical effect, and he couldn't get these images out of his mind. And that's not even knowing that child, not even seeing the evidence, but just hearing the child's account. This shows the reality of this on us. So the real question is, well, what can we do about it? And that's important. And one of the first things to note is the law, the area of the law is interesting because even though we aren't really talking about solutions, the problem is coming to light. In 2003, there was the first real study of STS among attorneys, Levin and Greisberg. And in their article, they went out and compared STS symptoms between attorneys and mental health practitioners. And what they found was that the attorneys had higher levels of secondary traumatic stress than even the mental health clinicians who were counseling people who had traumatic experiences. That was a major finding. In 2011, they were able to replicate the study on a larger scale with 238 public defenders at the Wisconsin Public Defender's Office, and their results were very similar, which suggests that attorneys are at greater risk, even though curiously, we aren't really presented with many solutions. In the mental health arena, they've developed lots of solutions, so that's quite important to think about. So we learn things from looking at police officers, mainly about the stigma of appearing unfit. We also have critical incident stress management tools they've developed there that are important interventions. The concept of a traumatic trial for jurors is important because it shows a one-time experience of trauma can lead to events, and judges, impairment of the quality of justice because of the effects of secondary traumatic stress. There's an analogy of a boulder in a river, right? The client's life is the river, the trauma is a boulder falling in it. The attorney stands in the river, maybe the boulder doesn't hit the attorney, but the ripple effect is there. And again, there's specific things to be cautious about, and I want you to look at the slide later, which talks about real examples of when you're dealing with sexually traumatized victims, what can happen when you are not monitoring the effects of secondary traumatic stress. And being unclear about proper boundaries, feeling like you have to save the client, having out-of-work connections, trying to just, this is one really big example, and then it could even get to the point of ridicule. You start to hate the client, hate the sight of the client, avoid the client. You start to neglect alternate theories because you're so invested that there's no other possibility, right? This has to go through because it's such an egregious case, so I'm not going to think about how to advocate for it except to point to how vicious it was. If all these other professionals are affected, are we immune from this? And the answer is, of course not. So again, what can we do about it? I talk about various solutions to this in the Ohio State Journal of Criminal Law article, and it falls on a spectrum. And the least intrusive is just talking about it, discussing it, right? What do we need to do? We can't repress this. We need to acknowledge it and then deal with it. And you can move forward to these different interventions all the way up to actually having a mental health professional help you. But again, this is not because you're disordered in any way. It's in order to deal with something that is considered an unavoidable occupational hazard of being a trauma worker. Something I tried to do in the article was, I've tried to find these self-analysis tools that have been developed for mental health clinicians and actually collect them in a single resource and got permission from the creators to reprint them. So you'll find various tools that might help you and discussions of those tools. This one, for example, the secondary trauma scale was recently used to assess asylum attorneys in those types of cases and the trauma they felt. So there has been some application to attorneys and evaluating attorneys. Importantly, note that you can monitor your level of reaction in these areas and how they change over time. So the idea is you don't just do it once, although it can help you immediately after exposure to trauma. You do it over the course of time to become aware of how your reactions are changing. Attorneys as first responders, just a quick point is different things in litigation or adjudication will set a client off. It's your obligation, if you help to prevent stress and stress triggers of litigation for the client, you're lessening your own chances of acquiring secondary traumatic stress symptoms. So it helps you. I talk about, these colliding forces, and one of the key points is this is an example of a veteran who's being tried for a crime. You could have trauma from the combat experience in military, PTSD triggers related to the commission of the offense that he or she's being charged with, forensic stress triggers just from the litigation separately, and the interaction of these different types of traumas increases the chances of symptoms playing out in relation to the adjudication or litigation. You're almost like a squad leader out there trying to guide your client on an azimuth to protect him or her against themselves. And there's different aspects I talk about of this enhanced client counseling role. The one I want to focus on here is taking the point, anticipating and avoiding potential threats. I've introduced something called the PTSD Trigger Awareness Plan. And what that enables the attorney to do is take an inventory of the client's past reactions, biggest fears about the current litigation, the way that the client reacts to things, how much exercise, sleep they have planned, what contingencies they have, and going forward, trying to anticipate the way the client might be triggered and doing something to avoid those results. Later we're going to have questions, but I just want to thank you so much. We've merely scratched the surface, but I want to thank you for what you're doing for those who've served our country.
Questions for Amy and Evan right now. If anybody wants to talk to them at the break, I'm sure they'll make themselves available. But if Sean Lee and Dr. Grant O'Neill could make their way down, that would be great. Anybody have any questions for Amy or Evan? Yes, ma'am.
You know, all the things of prior traumas, the thing that maybe you mentioned it in a different way. To me, it's the straw that, you know, broke the camel's back. In other words, it's a person has found ways to cope with all the prior stresses, and then it can be some small, what somebody might consider inconsequential trigger, and so the VA or whatever, even in personal life, thinks, well, that's a nothing. But it is the thing that finally brings everything like an avalanche to cause the problem.
That is so true, and what you just talked about is reflected in the research. They actually talk about different models of cumulative trauma, complex trauma. It's called, there's many different ways it's been studied, but you're absolutely right. And what they talk about is usually it's after a certain number of things, anything that happens could really bring the whole house down, just like you spoke about. So there is actually research support for what you just described, and I thank you for bringing that up.
All right, thank you, Evan.
My name is Sean Lee. I'll be introducing Dr. O'Neill. Quick note about myself. I served in the military from 2004 to 2008. I enlisted after I saw the towers fall, and I decided I was going to kill some of the people who did it. I served in Baghdad with the 10th Mountain Division as a scout sniper, and then in Afghanistan and Kunar province as a squad leader. With some of these deployments, I started to develop problems. I started to develop some of the things that we talked about here, self-destructive behaviors, inappropriate responses, negative thinking. The picture of the gun with the barrel facing backwards at the person pulling the trigger was really accurate. And one of the doctors that I have seen over the years has been Dr. O'Neill. He has been instrumental in my ability to even graduate law school. I think without some form of therapy, I probably would have done something self-destructive long ago and had some real problems getting through this process. Dr. O'Neill is the PTSD clinical team leader and an MST coordinator at the Truman VA Medical Center. While there, he basically talks to veterans like me, and he goes through several different PTSD rehabilitation processes. He's also a member of the VISN 15 Psychology Professional Standards Board, and he served as the psychologist for University of Missouri Behavioral Health and Family Counseling Center. He's also certified in cognitive processing, prolonged exposure therapies, and is a member of the American Psychological Association. Dr. O'Neill.
Thank you.
Thank you very much. Thank you for having me here today. I'm excited about the opportunity to be here. I'm really going to give two presentations today. The first presentation that I'm going to give has to do with the changes in the DSM-V diagnosis of PTSD. So I'm going to go through that first. The second presentation that I'm going to do has to do with screening and treatment for PTSD, military sexual trauma, specifically. So I'm not sure how to use this. Okay. Basically, I'm going to talk about the changes in a diagnosis in terms of the 4 components of the diagnosis itself. The first component is how the diagnosis itself is classified. Think of that as the neighborhood that the diagnosis is in terms of other neighborhoods, in terms of other diagnoses. The second is I'm going to talk about the stressor criterion. PTSD is one of the more unique diagnoses in that it requires a specific type of stressor in order to develop the symptoms of the criteria. The third thing I'm going to talk about are the symptoms of PTSD, and I'm going to talk about how those symptoms have been reconfigured. So basically, we're going to talk about the stressor, or excuse me, the classification. I'm going to use kind of an analogy, if you will, of that the classification is basically kind of the neighborhood that it's been in, and PTSD that it's in, and PTSD has been moved to a newly developed neighborhood. The second, in terms of the stressor, the entry point to PTSD has been more clearly defined. The third, the symptoms are kind of, once we're on the property, then we're going to see that the symptoms are configured differently and are more explicit in some ways. And finally, there are some specifiers or modifiers, which are sort of special parts of special kind of modifications of the diagnosis that may be present at some points in time. So the classification has changed. PTSD, starting in the 1980 DSM, has always been in the anxiety disorders criteria. And sorry about that. And the anxiety disorders includes things like has included things like social phobia, other phobias, generalized anxiety disorder, obsessive compulsive disorder, that sort of thing. It was moved for a couple of reasons. One, it was moved into a category called trauma and other stressor-related disorders to highlight that specific types of events or stressors cause these disorders. And so other disorders were also moved into this new neighborhood, so to speak. And that includes adjustment disorders, and for children, reactive attachment disorder are examples of that. So the other reason that it was moved is that anxiety wasn't the only or even oftentimes the predominant underlying emotion for the disorder. So instead, with PTSD, commonly we have fear, anxiety, anger, or dysphoria or depressive types of symptoms. So for those reasons, the diagnosis was moved. The stressor criteria, let's see. The stressor criteria has changed. And again, this is more the entry point. Basically, the signs of how we can enter this diagnosis or start is more clear, more explicit. So first off, the types of stressors have become kind of firmed up a bit. Exposure to actual or threatened death, serious injury, or sexual violence. And previously, instead of sexual violence, it said violation of physical integrity. So it was kind of an unclear what was being asked for there. And so then the second change has to do with adding some of the things that were previously in sort of the narrative, and we sort of understood that this is what we were looking for, but then also some changes that Major Simon, thank you, sorry, spoke about before. So they have to do with the qualities of exposure to the trauma, and specifically some things in terms of how close to the trauma was, how intense it was, how frequently it occurred, that sort of thing. So the first is direct experiencing. Directly experiencing actual or threatened death or serious injury or sexual violence is witnessing it in person, seeing the event happen to somebody else is also a way of entering the diagnosis. Learning that the event occurred to a close family member or close friend, somebody that we're very close to. Sometimes somebody we may feel safe driving in an automobile until a close friend is in a car accident and seriously injured or killed. Experiencing repeated, and this is what Major Simone, thank you. Experiencing repeated or extreme exposure to aversive details of traumatic events. And we both use the same quote out of the DSM-V for that. First responders collecting human remains, police officers, etc. The subjective criteria that was in DSM-IV has been dropped. That was the criteria that the individual at the time of the event or shortly after was required to experience an intense sense of fear, horror, or helplessness. That was dropped because those characteristics of the trauma response are not correlated or not associated with the eventual development of PTSD symptoms. So that's why that was changed. I'm getting the hang of this thing now. So now we've entered the property, so to speak, and some of the changes that have occurred. There are 4 symptom clusters now in the PTSD diagnosis. There used to be 3. The 3 that we used to have were called hyperarousal, avoidance and numbing, and re-experiencing, and I got them backwards. Re-experiencing, avoidance, and hyperarousal. The re-experiencing symptoms are still the same as they were before, but they're referred to as intrusion symptoms now. Re-experiencing was kind of confusing for many of us to understand. What do you mean we're re-experiencing the trauma? So with the intrusion symptoms, basically these include things like memories or images of what happened that come uninvited or involuntarily into our mind and are distressing or disturbing. That can include nightmares or disturbing or distressing dreams, that sort of thing. It can also include having very strong psychological or physiological reactions in response to reminders of the trauma. So those are the intrusion. You have to have, this is almost a cardinal symptom, if you will, you have to have at least one symptom from the intrusion category to meet the criteria of PTSD. Other symptoms that are involved may or may not be related to PTSD, may also be associated with others. So this is very much kind of an entry point as well. The avoidance and numbing symptoms was one category, has now been separated into 2, and some language has changed to make it more clear. Instead of simply avoidance, persistent avoidance. And then we've added is negative alterations in cognitions and mood. Persistence has been added to highlight the idea that it isn't just the occasional avoidance of activities or places or a preference not to do certain things like go to Walmart or what have you, but that it's a persistent avoidance of those kind of situations or activities, people, places, things, and ultimately the thoughts and feelings, the emotions that are related to the trauma. but that's persistent. Negative alterations in cognitions and mood. Changes in cognition can include inability to remember important aspects of the trauma. That was there before. Persistent, exaggerated, negative beliefs or expectations about self, others, or the world. These can be very exaggerated negative expectations, beliefs like I'm broken, like the world is a very dangerous place, I'm not safe at any time, other people mean me harm. Persistent distorted cognitions or beliefs about the cause and consequences of the trauma or traumas resulting in excessive blame of self or others. So this can include things like if I had just declined or my officer's directive not to go on duty that day to do something else, then my friend wouldn't have been killed in that IED. Or if I had not gone down the street and walked, I wouldn't have been attacked. Or if I had anyway, you get the idea. So mood changes may include marked diminished interest and participation in significant activities. So things that normally we would expect people to engage in, involve in, things that they would have been likely to involve themselves in before, they're much less likely to do so. Feelings of estrangement or detachment from people, feeling like I can't have loving feelings or caring feelings towards other people, not feeling connected. Sometimes it comes out as a feeling of estrangement, like a sense of that I don't belong, I'm not like other people, that sort of thing. And so it's kind of can be a very strong sense of isolation or alienation. And persistent inability to experience positive emotions. So sometimes the affect or the kind of emotion tone that the person seems to have, this sort of their baseline, may be very neutral or maybe even a bit dysthymic or detached, but also has difficulty feeling those normal sense of joy or pleasure or pride or those sorts of things that we might experience with life events like seeing the family for Christmas or having a baby or any of those kinds of things. And then finally, what were called hyperarousal symptoms is relabeled marked alterations in arousal and reactivity. And there are some changes here. It used to be irritability and anger outbursts. Now it's irritable behavior and angry outbursts with little provocation. It's typically expressed as verbal or physical aggression towards people or objects. So getting a little bit more behaviorally specific about what meets that criteria. And reckless or self-destructive behavior is one that's been added added in this category. Most of the others are the same, by the way. I'm not including all of these, but the reckless and destructive behavior may include extreme risk-taking, driving at extremely high rates of speed, etc. The ones that have stayed the same include what we call hypervigilance, that extreme guardedness. You also, oftentimes, if you see somebody with hypervigilance, you'll see them scanning. If you see them come into your office, you'll often notice that they're taking particularly close they're particularly closely examining, that's a poorly worded statement, windows, doors, the possibility that somebody might be able to enter, where there might be weapons, those kinds of things. So, but anyway, so hypervigilance, concentration. It's very difficult to concentrate when much of your time is spent looking for the potential dangers. How might I be attacked again? What might harm me in this room? That sort of thing. Sleep disturbance, aside from the nightmares, just general sleep disturbance, particularly difficulty falling asleep or staying asleep. Also, the duration of sleep. I would guess that the duration of sleep for individuals with PTSD on average is about 4 hours. And so, let's see, what else was there? Oh, I think I've kind of covered them. Oh, extreme startle reaction. Finally, what we have are what we call the specifier changes, or the specifier. The specifier isn't part of the diagnosis itself. With the diagnosis, with the categories, with the 4 categories of the diagnosis, we have to have one of the intrusion symptoms. We have to have one of the 2 avoidance symptoms. We have to have 2 of the negative alterations in mood or reactivity symptoms. To meet the criteria, let's see. And so these aren't part of the criteria, so to speak. They're more like modifiers or special features, if you will, that are related. One is that has been added, and that's with dissociation. Dissociation includes a sense of, may include a sense of depersonalization. That sometimes you may have seen that depicted on TV shows or that kind of thing, where somebody's been assaulted and talked about having experienced it as if they were watching the assault happening to them from the outside, that sort of thing. So, like, it's not really happening to me. The derealization is where the individual has the sense that this experience isn't really happening. It may have a dreamlike quality, or may kind of have some distortions in the way that reality seems at that point in time. So that's been added. A second specifier was changed. In the past, we used a specifier called delayed onset for somebody who didn't present and said that, and would oftentimes say, I never really experienced these symptoms until some life event happened, until I had my first child, or until I reached retirement age, and that sort of thing. But what we've actually learned from research is that in virtually all of those cases, some symptoms of PTSD were present prior to the full-blown meeting of the criteria. And so the change is to delayed expression. And finally, we dropped the chronicity specifiers. So in the past, it takes 30 days. If somebody experiences the symptoms of PTSD, within the first 30 days, we don't diagnose PTSD. If it's longer than 30 days, it used to be that if it was 30 days to 90 days, essentially, then we would record that as an acute episode. And more than 90 days, with just 3 months, we called it chronic. We know now that PTSD is treatable, that it doesn't have to be chronic after that 90 days. And an important thing to know that I want to point out here is that we also know that if the symptoms last more than 1 year, they are very unlikely, virtually impossible, that they're going to get better without professional treatment. One of the things that oftentimes happens during the first year of having a trauma is most of us will do the same kinds of things. We think it's going to go away, or we think, I can deal with this, I can work through this on my own. And we may reach out to family, friends, other professionals like a primary care physician or what have you to help us with this. So, and that's understandable, and it's something to be supported. But I want you to remember that timeline. If it's more than a year, it's not likely to get better without professional help. So, and that's that. And Angela, you wanted me to? And did anybody have any questions or? comments on that? Yes. Okay. Both, and I'll actually talk about that in this next set of slides. Cool. Thank you. Yes.
So would you say with the changes in the DSM-V that it's more or less people will meet the criteria for a diagnosis of PTSD?
Virtually the same number of people are going to meet the criteria of PTSD. I believe if I remember the numbers, it's slightly less. However, if somebody would have met the criteria of PTSD before, they're likely still to meet the criteria of one of the other trauma or other stressor-related diagnoses. And the one is called other trauma and stressor-related disorder, specified or unspecified, depending on whether you're talking about, whether you're identifying what prompted it. And then the other is the adjustment disorders were moved in to that. And so, and the trauma or other specified trauma-related disorders is oftentimes presents like a prolonged adjustment-like disorder as well. Did that answer your question?
There's one more. You spoke about the need to reach out to other areas to help the PTSD survivor. What about the families? Are there programs underway through the VA that allow dependents to be counseled or trained so that they can also help the family member in crisis situations?
That's a good question, and it's actually one of the areas that we need to grow. Is that the question has to do with are there programs for family members, and particularly for family to help in situation of crisis, like the family itself and that sort of thing. We do. I'll actually get more into some of those programs here, but that's one of the areas that we have some growth to do. Yes.
Advice do you have for a family member or friend who sees someone who appears to be having trouble with PTSD as a crisis? What should they do?
Okay. So if you have a family member or friend who has a family member or friend with
If you have a family member or friend who is exhibiting symptoms of PTSD, what advice do you give to that person and how they can help their friend or family member?
Okay. In terms of helping them to get treatment or in terms of just helping them?
Both, I guess.
Okay. One thing across the board is to normalize symptoms. Knowing that person's experienced trauma, one of the things that we know about is the symptoms of PTSD are kind of a natural response to that. And where it becomes trauma in some ways is when it overwhelms our ability to process and thoroughly come to terms with that situation, and so that those symptoms continue. We oftentimes, I'll talk about this in the next part of this presentation or the next presentation, but we think of PTSD as being a problem with recovery as opposed to a problem with the symptoms themselves. Unfortunately, what oftentimes happens is people, blame themselves for the symptoms, or they think I'm broken or something's wrong with me, or I'm crazy or that kind of thing. And so normalizing the symptoms. Another thing is to encourage them, letting them know that this looks like what it might be, but we're not clinicians. I'd like you to, I'd encourage you to see somebody. There's help for this, and support the person in that. Things not to do or to push. When we push, what happens is that. In some ways, I talk about PTSD a lot of times as being a diagnosis of vulnerability. It's when we experience trauma, we're experiencing what is likely the most vulnerable moments in our life, whether that's repetitive or a single incident. And so one of the things that we want to do is to bolster the person's strength, the positive things about themselves, and we don't want to do things that may undermine that sense of self-efficacy or agency. And so letting the person know that you have support. Social support is the strongest predictor of resilience before trauma, of reaction during trauma, and of recovery after trauma. It goes through. So that's really important, normalizing those symptoms. And again, giving them the choice, but letting them know that you're going to be with them or support them either way, that it is their choice. So did that answer your question? Okay. Yes.
Angela, is it okay if I ask?
Yes.
A lot of times, I guess in the common vernacular, PTSD is something that happens because something happened to somebody. There's a group of vets, and there's a few people in this room that I know that we were self-medicated. We were seeking those incidents and running towards loud things. And is there anything going on with PTSD treatment that deals with that type of person that's the quote unquote adrenaline junkie that was living off of that stuff?
The question is there anything done with the increase in essentially risk-taking and that kind of thing? And of course, you saw that it's actually now part of the diagnosis itself. And one of the things that we would likely do with that is that would be one of the features, the diagnosis, that we would look at and incorporate into the formulation of how it is that we're likely to be able to help or work through with the person. Oftentimes, what that really is, and I don't mean to, okay, what that is it's an avoidance of those thoughts and emotions related to the trauma, and it's also oftentimes an attempt, particularly in some of those reckless, driving really fast or whatever. It's trying to get back some of that sense of mastery that was lost, again, in that very vulnerable situation of trauma. So basically we would use standard methods, but that would be more the content or the process of it. Did that answer your question? So it's a good question. Thank you. Yeah.
We're going to, Grant has one more portion, and we're going to break at 10:05, and you can catch the questions after that. But if you want to take a few more now, that's fine. Just
How much time do I have?
You have until 10:05.
10:05. So I've got 10 minutes. Is that right?
Yes.
Okay. I've got 10 minutes. Okay. So I'm going to skip through a lot of stuff. Okay. The main points on this are that we screen all veterans for military sexual trauma, all males, all females. As of last year, we should be getting our fiscal year 14 data in the next 4 or 5 months, I would think. But so these are based on the 13 data, but 98.6% of veterans have been screened. I'll cover that in a second. Women are almost 20 times more likely than men to experience MST. However, through the years, when I first became military sexual trauma in 2007, I believe there were about 32,000 veterans that had screened positive that were male and also that were female. More recently, I've noticed those numbers starting to diverge. So we are starting to see a higher rate of women in the military, or women experiencing positive screens. And so you can see that discrepancy. It's about 78,000 females, about 58,000 males having positive screens. All veterans are screened. Virtually all VA providers have completed required education to be able to respond effectively to someone, to be able to administer the screen, as well as to be able to respond effectively and compassionately to the individual who has the positive screen. The screening does not require disclosure of the incident. Generally, a label is Standardized questions are behaviorally based to avoid confusion about what we mean. We don't ask somebody, did you experience sexual trauma or did you experience military sexual trauma? Because they may not know what that means. But so the screening questions are very explicit. If it's positive, they're offered a referral for consultation or treatment, and that screening can be changed. They can decline or they can deny it, but at another time come back and say that they have experienced that and have that changed. Oftentimes that happens because they don't feel comfortable either in the situation or at that time with that. The screening is once in a lifetime unless the person is active duty or redeployed, and then that initiates the screening. So, did that answer your question you had? Okay. Major Simone went through this pretty much before, so I'm going to skip this screen altogether. There are some treatment benefits or service benefits is probably a better way of putting it that veterans with an MST positive screen have. One is that they're generally eligible for MST related care even if they're not otherwise eligible for VA care. That's for all physical and mental health diagnoses that the clinician believes is related to military sexual trauma. They're eligible for free counseling for all those conditions. Neither the veteran nor their private insurance is billed for services. There's no time limit. It doesn't have to be reported, and et cetera. And Ms. Odom covered about the veterans' benefits, so I'm also going to skip that. That's been upgraded. So I'm going to go through basically services we provide include triage, where we basically assess the person for their safety. We determine what kind of initial resources they may need. So for example, if they need homelessness services, they may get a direct referral to homelessness services. If they need to be hospitalized, that would happen. That would also generate a referral to the appropriate teams in terms of behavioral health care, and I'm talking specifically within behavioral health at this point in time. So in terms of once a consult or request is placed for the team, and I'm going to stick with my team, the PTSD team, then that will be assigned, it will be scheduled generally within 14 days, and the individual will be provided with education about what we're going to do, what our services are, and an assessment and treatment planning specifically devoted to their concerns. So some of the treatment things that we have is that there are PTSD treatment is oftentimes thought of as being treatment in 3 phases. The first phase is a stabilization phase. That includes safety, but it also includes having safety, but not just in terms of suicidal ideation, but also in terms of, are you in a safe place to live? Are you in a place where you're able to do this kind of work, that kind of thing. It also involves emotion stabilization, helping the person to be able to recognize their emotions, label them, and process or monitor and regulate them effectively if necessary. We have some specific programs that do that. Also, there's frequently, particularly with sexual assault survivors, there's oftentimes significant interpersonal problems, and you can I clearly understand why. And so 2 of the programs that we have, skills training, and I should have put affective and emotion and interpersonal regulation, and the acronym is actually STARE. That's about a 12-session. As a 12-session group program, we can also do it individually to help the person develop emotion regulation as well as interpersonal skills. For individuals that it's more severe and have self-harming behaviors, personality disorder, or other, we have a dialectical behavioral therapy, or DBT, which includes some of those components and additional. We also have a number of skills groups, and we also skills-based programming and that sort of thing. I'm going to skip forward to our trauma-focused treatments. I'm not going to cover each of those, but I'm going to give you kind of some of the commonalities of them. We have 2 treatment programs, both of which were developed based on sexual trauma and have been used for sexual trauma as well as combat and other forms of trauma since, and have been found to be effective. The VA has rolled out an initiative to train providers within every facility to be trained and certified in one or the other of these protocols, cognitive processing therapy or prolonged exposure. By every provider, I mean every trauma provider. So, but there are providers in every facility. Basically, we explain how the symptoms are caused. It was one of the first things. Education is so important, that having an understanding of that these are symptoms that are caused by your exposure to trauma and why they're caused that way, and an explanation that makes sense to them. Also providing an explanation of other common features like psychosocial functioning issues, other diagnoses or symptom issues, that sort of thing. And as I mentioned earlier, we consider the symptoms themselves to be a natural response to trauma, but that recovery is essentially unlocking the recovery. It's about recognizing what blocks the recovery. We provide a plausible explanation about how treatment works. And basically, we generally target an incident that causes the most distress for the person to help them get the most impact out of addressing that. Some of the things that keep recovery from taking place are those maladaptive beliefs that we talked about. I can't trust anyone. If you just think for a second about if that was a belief that was kind of core or held very emotionally tight, so to speak, you can imagine what it would be like to be in this room like right now, for example, or even to consider coming to something like this. Another is what we call avoidance, or basically, and that's where the exposure that comes in. Cognitive processing challenges the beliefs and helps the person to evaluate the beliefs, whereas the exposure therapies challenge more of the avoidance and help the person to face not only the memories, but also the situations that are objectively safe or reasonably safe, but that may be avoided because of the symptoms. So that in a nutshell is what we do at the VA. And did I answer your question going back to? Okay, good. So thank you very much.
And we are live streaming. I should have said that earlier, and we will be posting materials up to the website. Yes. have an influx of more students right around 10:30, probably, so they'll move in the back. Everybody else, please be seated so we can stay on time. And Matt Schock, one of our students, will introduce this panel. Thank you.
Good morning. My name is Matt. I'm a student and volunteer for the Veterans Clinic here. I'd like to introduce our guests for the third and final panel. This panel will be discussing practical tips for representing veterans who suffer from mental health issues. I'd like to introduce, and if you just raise your hand so everybody knows who you are. I'd like to introduce the Honorable Michael Brady, who is an Associate Circuit Judge for Division 9 of the 13th Judicial Circuit of Missouri. Division 9 presides over DWI Court, Mental Health Court, and Veterans Treatment Court. The Honorable Mr. Bradley served 15 years as a statewide special prosecutor for the Missouri Attorney General's Office. The next speaker I'd like to introduce is Ryan Gill. Ryan is a student veteran here at the university. He was mobilized for both Operation Iraqi Freedom and Operation Enduring Freedom. He currently serves as president of the Mizzou Student Veterans Association, and he serves on the board of our local veterans shelter, Welcome Home. Our final speaker is Tim Harlan. He's a partner at Harlan & Still in Columbia. He served in Missouri on the House of Representatives for 4 terms, I believe. He has represented Social Security disability claimants for 34 years. He has a keen interest in mental health issues, serving on the National Alliance for Mental Illness for 9 years and 5 years as its president. Thank you.
Good morning. Again, I'd like to reiterate the Dean's thank you to all of you who have served our country. We wouldn't be enjoying our freedoms and our rights and our responsibilities without your service. I do appreciate that. And I also want to thank those persons who are helping the veterans, because we need to, if it wasn't for you, we would be letting them down. I came to working with veterans treatment courts through some personal experiences and just some looking at the situation. I can't help but remember, I was thinking about this morning, today's Veterans Day, which used to be called Armistice Day, ending of World War I. My great uncle had mental health disabilities in World War I and spent his entire life in a veterans hospital till he passed away in his 80s. I have known other family members who had mental health issues coming out of World War II, had a very disruptive life, and then died prematurely. As a special prosecutor, I put in prison a Silver Star winner from the Vietnam War who repeatedly was driving drunk. And I emphasized, and I was able to convince the judge to put him in prison for maximum time, not to help him, but to keep him from killing somebody. But I always remembered, because his defense attorney used his military experience as a tool for leniency, which I would have done if I were his position. The man fought in Vietnam, volunteered to go. He was a gunner on a helicopter that picked up our downed pilots. After the first helicopter wave was sent back, he volunteered to go the second wave and saved the pilot, came home, drank a fifth of whiskey every day for the rest of his life, and I put him to prison, and I always thought I wish something else had been done. So through our country's history, Americans have answered our call to service. Those who serve often are affected both physically and mentally. Some of the veterans, especially the ones with the mental problems, end up in our criminal justice system. That's where veterans treatment courts provide a proven method to address those issues facing the veterans. Our veterans treatment courts are not get out of jail free cards. We thank the persons for the service, but they have to uphold the responsibilities. The issue of guilt is determined not by the Veterans Treatment Court, by another court. The Veterans Treatment Courts, people, I've mistakenly had people say, well, why should veterans not have to obey the law? It doesn't have anything to do with that. Another judge, another court makes a determination whether the person is guilty or innocent. If they're found guilty, they're brought into the Veterans Treatment Courts. Veterans Treatment Courts try to resolve the issues that brought the veteran into the criminal justice system. Whether it's post-traumatic stress disorder, traumatic brain injury, drug abuse or alcohol abuse, or sexual abuse, those are the type of issues that are manifest with somebody going out, self-medicating, getting into drugs or alcohol, making bad decisions, and end up getting in the criminal justice system. Evidence proves that simply warehousing a person in jail or placing the person in a moderate or low supervision probation is not effective in treating the deep-seated issues. The first Veterans Court was established in Buffalo, New York in 2008. Our team here from Columbia was privileged to visit, observe, and learn from Judge Robert Russell and the experienced Veterans Court team in Buffalo. Judge Russell tells the story, and I'm going to repeat it because it's a great story. He was involved in a drug court. He had an individual who served in the Marines in the drug court. The individual was about to be terminated from drug court because he simply wasn't responding to treatment. He wasn't doing what he was asked to do, wasn't going to treatment. He was testing positive. His bailiff, who also served in the Marines, asked the judge, said, do you mind if I go talk to the guy? Judge said, nothing else worked, have at it. The bailiff basically took the individual out in the hall and said, you're a Marine, act like a Marine. And the difference was noticeable, where the individual would come in to, and what happens in these courts, they come in and talk to the judge. When the individual would come in to talk to Judge Russell, pre the conversation, okay, yeah, I'm doing okay, I'm doing whatever. After the bailiff said, you're a Marine, act like a Marine, the individual came in, stood at parade rest, yes sir, no sir, got with it, got with the program, and turned his life around. That led Judge Russell to believe that maybe we should do something different for veterans than just putting them in our other treatment courts. In Missouri, our General Assembly has showed its confidence in veterans treatment courts by passing a bill to establish veterans treatment courts, and Governor Nixon signed the bill and made it law. With regard, just kind of an explanation of treatment courts. Boone County has been a leader in treatment courts. The old options, as I mentioned, were incarceration or low-level probation. We either put somebody in jail, they didn't get help for what their underlying cause, they got out, made bad decisions, went back to jail, and as lawyers and judges you can talk about, you see them over and over. Or they put on probation, and probation is never funded enough. They never have the resources to do intense things. And they go on probation, get revoked, go to jail, come out, do the same thing over and over. The treatment courts were instituted to reduce this recidivism. The idea behind treatment courts is to require the individual to remain drug and alcohol free and to attend treatment. Boone County currently has a drug court for individuals with drug addiction history, mental health court for persons whose mental health issues bring them into the criminal justice system, and a DWI court for persons whose alcoholism has caused them to receive 3 or more convictions for driving while intoxicated. In 2013, Boone County established a Veterans Treatment Court. In Missouri, we joined the City of St. Louis, Kansas City, Pulaski County, and Butler County as jurisdictions that have Veterans Treatment Courts. And other counties, such as Cole County, are looking to establish a Veterans Treatment Court, and we encourage all that. There are additional expenses for these treatment courts. We have a coordinator who keeps track of all the files, keeps track of the treatment, keeps track of the drug testing, keeps track of the budget, make sure we do all that. And we have a part-time person who is a mentor coordinator. And that person recruits and schedules and does the background check on our volunteer mentors. On a personal note, no additional expenses, the judge doesn't get paid anymore, which is fine. But Boone County was fortunate to have Columbia's own Veterans United home loans through the Veterans United Foundation fund a significant portion of these expenses. Without the help of Veterans United, our Veterans Treatment Court here in Boone County would not exist. The participants in Veterans Court are given a challenging task. It is not easy. Veterans Court lasts at least 1 year. Our first veterans were transferred from the other courts. We had veterans in drug court, mental health court, DWI court. We brought them all in, and they started there. The veterans are required to attend and successfully complete the treatment provided by the Veterans Administration. The veterans are subject to random drug and alcohol testing. They must call every day. When they come into court, they're assigned a color. Those who have yellow, orange, or red this morning had till 10 o'clock to go give a urine analysis. And these are random. They're given multiple times during a month. The idea is if they start guessing, hey, I'm not going to see anybody for a couple weeks, I can drink and use drugs tonight. As I tell them, if they are that lucky, buy the Powerball ticket, because your odds are not that good. So the idea is just to put something in their head. When their relapse trigger comes in and they're thinking, I'm not going to see the judge for a while, I won't be going to treatment for a while, I tell them the next thing you need to think of, if your color's red, you may have red in the morning, and then we're going to get caught. So just think, well, I'm not going to do it. I may have red in the morning. Do that one day at a time. You kind of get in that AA thing of one day at a time, and it helps keep them sober. If the veteran is successful in the program, they avoid jail or prison. That's part of the deal, is instead of going to jail, instead of going to prison, you're going to go successfully complete the program. If the veteran's not successful, then the veteran appears in front of the original sentencing judge and will face the consequences of his or her actions. Once in the program, the veteran initially attends court each week. Then as the veteran is being more successful, we start skipping weeks and moving out. But during the entire time they're in program, they're subject to the random urinalysis and they're subject to going to the veterans treatment. If they come back, when I see them, if they come back and they haven't been going to treatment, they've got an issue. We have, before Veterans Court, we have a team that works. One of the things that's great about these treatment courts, it's just not the judge, it is an entire team. We have people from mental health, we have people from probation and parole, we have our coordinator, we'll have attorneys on occasion, and we sit in and discuss, this is what this person's done this week. If it's great, we congratulate them, tell them to keep it up. If it's not, we try to figure out what we're going to do to solve the problems. And then we go out and the veterans appear in front of me and then I talk to them. We have our Veterans Treatment Court has a great working relationship with the Truman Veterans Hospital here in Columbia. We have all of our veterans get all their treatment through Truman's Hospital. They provide the treatment, they provide the insight. Danielle Easterly is our coordinator that works between us and the hospital. She lets us know if somebody's not going to treatment or what the resources are available. But one of the most important parts of our veteran court is the volunteer veteran mentors. These are veterans who have volunteered their time and mentor the veterans in the court. The mentor program separates this court from the other treatment courts, and it is found to help change around the lives. I am grateful for our volunteer mentors, and I know their service has provided a lot of help to our participants. There are two main reasons why the Veterans Treatment Court has succeeded with regard to veterans where the other treatment courts have not. One is we tap into their military training and culture. In addition to the United States and state flag that we have in all our courtrooms here at Boone County, For Veterans Treatment Court, we adorned the courtroom with flags of each individual service that the VA donated to us. Before court, one of our participants leads us in the Pledge of Allegiance. The unit cohesion that the participants had when they were on active duty, we attempt to rekindle it. The participants will engage with each other, and some participants will help the others work their program and vice versa. The whole idea is once they're in Veterans Treatment Court, as a cohesive court, we don't want to let the other veteran down, and we want to help the other veterans. I have noticed situations, especially the ones who came from the other courts to come over, where they have actually worked harder in the Veterans Treatment Court than they did in mental health court or drug court because they didn't want to disappoint the other people in the court. And I think that's a big thing. And that goes back to their military culture. I mean, they fight for their buddies, and that's exactly what we try to tap into to move them forward. On their own, their body language is different. I noticed the same thing Judge Russell noticed. People don't come in, have their heads down, have bad posture. We don't instruct them to do it, but most of them come in and stand at parade rest when they come to court and stand in front of me. And that's something we don't emphasize, we don't tell them. They just do it. That's because they're in front of their fellow soldiers. The other reason that Veterans Court are so much more successful than the other courts for veterans is the mentors. The volunteer mentors are a key element. The mentors aren't counselors. The VA's the counselors. They're the ones who provide the mental health treatment. Veterans, the mentors don't provide mental health treatment. Instead, they're basically a friend with common experience. I served, you served, we got a lot in common. I mean, even if it's different branches, we don't necessarily match them up by branch. Even if it's different branches, even if it's different eras, there's a commonality between people who have served, and we tap into that. The veteran mentor meets with the mentor about once a week. They do things like visit with them, give them possible leads to employment. We had one mentor allow a participant to use his vehicle because the participant's driver's license had lapsed and he needed to practice practice his driving so he could pass the driver's test. The mentor did that on his own, wasn't anything that came to us. Passed the test, now has his license, is moving forward in his life. Whenever, and this is an unexpected consequence to me, whenever I thank the mentors for the help, they tell me that the experience of them helping the veteran in trouble was as rewarding to them as it was for the participant. And I've heard that from numerous mentors, and that's just, it's a great unexpected consequence. Because I'm thinking of helping them, but they've said it's helped them. Our Veterans Court has had some wonderful successes. We've had multiple graduates. One success that I'll always find close to me because he was one that we moved over. We had a veteran who was totally disabled. He'd served in Iraq. He'd suffered trauma, probably some brain injury. Before the Veterans Court was established, I had him in the mental health court. We didn't see any progress in his condition. After 3 or 4 months in mental health court, he was doing about the same as he came in, wasn't doing anything better, wasn't doing anything worse. He, because of his conditions, was fearful of open spaces, did not like to be in broad open spaces, did not like to ride in cars, did not like crowds. One of the things we tried to get him to do at mental health court is go to Walmart. He didn't want to go to Walmart because he didn't like being around people. His experiences over in Iraq and what he had went through had caused this. And they also had caused his issues that got him in the criminal justice system. There were times where he would come in and say either to me or treatment providers or probation and parole, you know, if this is as good as I'm going to get, why am I even going to go forward? Which is a big red flag. Really, we're worried about him. We moved him into Veterans Treatment Court. With the help of the VA and his mentor, he came out of his shell. He turned his life around. Quite frankly, I hardly recognized the guy that graduated from the guy that started. We was able to not only go out in public and go to Walmart and kind of overcome some of his fears around him. After he graduated, his plans that he followed up was he bought a car and he went around the country and visited friends of his that he knew from the military. This is a guy, a year before, wouldn't get out of his house to go to Walmart because he didn't want to be around people, who now is driving across the country. That was a great success, and that's one that I think really shows the importance of the Veterans Treatment Court. Our goal in court, of course, is to leave no veteran behind. We're really happy with it. If it wasn't for Veterans United, we wouldn't have it here. But we've really had some success with it. I don't want anybody to be that everything's roses. We've had some failures too, but more often than not, we've had successes. And I thank everybody. And if anybody who is a veteran wants to become a mentor, Angela has left some of our applications outside, and we'll be happy to take any. Should I do questions now?
Sure. Yeah.
Okay, I've got one.
I was just wondering what options might be available for veterans, say, living in some of the outlying rural areas, say like Lynn County, where they're outside the jurisdiction of Boone County. Is there any kind of relationship set up between your court and some of those courts where they could get referred here because they still live in the VA service area for treatment?
We're working on it. We're hoping to, like the court down in Butler County has 13, they have multiple counties. They go all around, and it's all focused on their VA hospital there in Poplar Bluff. We're trying to, at some point, we didn't want to do, and this was my decision, I didn't want to go out and reach out to other counties before we figured out what we're doing in Boone County. We've got some problems that we have to overcome before we can do that. Now, if somebody from Lynn County were living in Columbia, we can make arrangements to do that. There's some legal issues that we have to address, and there's some practical issues. I mean, if somebody's up in Brookfield or Marceline, and they have to come do a drug test in Columbia, it's not going to work. And we do see them once a week, and the transportation's not going to work. What they do down in Butler County is they work with the VA to try to get everything scheduled in Poplar Bluff at the same time. So we're going to look to do something like that. Unfortunately, I'm not sure veterans courts will really make it statewide just because the resources. I mean, smaller counties, if you got one or two veterans, drug courts have gotten pretty much statewide, but veterans courts are going to be more difficult to do. But we're going to do some outreach on some adjoining counties to try to get some help. Okay, thank you all for attending this morning.
Good morning. Thank you for the warm introduction. I guess first I should apologize. I'm no judicial sage. I don't have a law degree. I think I'm the only one on any panel without any sort of professional degree, so I'm going to abandon my post and walk around here a little bit. So I'm Ryan Gill. I'm president of the Student Veterans Association here at Mizzou, and I get to wear another hat. I'm in a pretty unique opportunity here. I also serve on the board of directors at Welcome Home. For those of you that are unaware with Central Missouri, the doings of the veteran community, Welcome Home is a homeless veteran shelter. It was started in 1992 by a group of Vietnam veterans that gathered their resources, and one of the individuals actually put a mortgage against his own home to develop this shelter. A pretty incredible story, and we've made it leaps and bounds from there, from the time it started to the time where I was able to serve on this board. And today I wanted to talk about the two veterans that I get to spend time with. Here at the university, I'm surrounded by veterans, and the number's 360 plus here on campus. They have varying majors, varying circumstances stemming from their service, but largely the individuals here on campus, they're leaders in their community, they're leaders in the classroom, and they're setting the standard for society. They're doing these incredible things, but you don't hear about the two-tour Marine Corps veteran that stays up late studying for a statistics test and gets an A- on it. But we don't want to undermine away from the issues that what we're here to talk about today is post-traumatic stress disorder, military sexual trauma, traumatic brain injury, and so forth. And that's more of what we see at Welcome Home. And there are two identifying factors that I think it would be important for an attorney to remain cognizant of and be mindful of these things as you're going and pursuing these cases, which I'm incredibly grateful as a veteran for your efforts. I think you're making a more suitable environment, not only for myself, but for those individuals that are going to fight years on down the road as this country keeps going. Number one would be the generalizations of veterans. I think it's common for people to try to put veterans in a box. And when you think of a military personnel member, you think of this one individual as occasionally or typically stoic, they're strong-willed, desirable traits and characteristics that we all would like to embody. But the thing is, veterans they're so much more than that. They come from different walks of life, different backgrounds, different jobs in the military, different branches of service. So just because, Sean here was an 11 Bravo infantryman, United States Army, we have cooks in the Air Force and the Navy that have had just as traumatic experiences because they were going from one base to another and they were in the wrong place at the wrong time. So just because someone serves in a non-combat role, that does not mean that they haven't seen some of the worst set of circumstances that we would never wish upon another human being. Another thing that Judge Bradley, if I could reiterate, was the success that we see in the MSVA and also at Welcome Home is when you can duplicate the camaraderie of the military. That's when you can really make a connection with veterans. And you can create an environment that they're more willing to open up. It's something that they're comfortable with. It's hard to express. I think often of, as I'm going to class or I'm coming to speak, and I think about how sometimes I miss the military, and I miss Iraq even. How crazy is that? Colombia is a wonderful place. Mosul, Iraq, Samara, I've been there, and you can keep it. They're not, it's, I wish the best for them, but sometimes I find myself, and I'm like, how absurd, I miss that. And the more I think about it, I don't miss first formation. I don't miss the Army. I don't miss deployments. I don't miss time away from my family. I miss my guys. I miss my friends. I miss that. It's such a unique bond when you're, in a distant land with someone, and you know that they're willing to go that extra mile just for you. Likewise, you are for them. So if you can ever recreate the camaraderie aspect of the military, I think that's going to set you up for success in your endeavors in your legal career. I'd like to thank each of you for coming today and sharing on this occasion. I think it's turned out to be a wonderful inaugural event, and thank you for your time.
Thank you.
Right.
VA, and we're just really lucky to have him. And he's a future lawyer. He's hoping to enter law school.
Yeah, I hope that's not the only time I speak here. Dean, you're on here somewhere.
Family says, why don't you forget? I'd like to, but I can't.
I don't know if I was sexually abused as a child.
I was confused as a kid, how adults could let things like this happen.
I'm upset because they didn't do anything when I went to tell them.
The photographs are free photographs on the internet. The comments are things that I've heard from clients, all of them. And as I was reading a book one time, I swear I'd read it at night, and the next morning I would go in and hear the same thing at the office. I couldn't tell people what my uncle did because my aunt is such a wonderful person, so I couldn't tell anybody. I would first like to thank the law school for what they're doing, because this is time and resources that could go to something else for both this and the class. Also, the veterans for your service. Judge Bradley for getting into something that I know was difficult when he started this with the special courts, and in fact, I don't think he would care if I told this story. On about the second week, I think he was still observing Judge Carpenter, and he said someone came in and he thought, why are we wasting time on this person? And the next week, he saw something different and said, now I see why we're doing this. Now I think we can help him. It's a difficult learning process. What I would like to do is talk a minute about some of the veterans that I have represented. My practice is Social Security disability, and although I've done it for 35 years, I didn't realize that sexual trauma was going to be such a big part of our practice. 40% of our female clients have sexual trauma that is mentioned in the medical records. So that doesn't include the ones that it's there but is not mentioned. Much smaller number of men because it's very underreported with men. I remember one man that had been in Iraq, had a confirmed head injury, serious psychiatric problems, was receiving full VA benefits, had been turned down by Social Security. And when we filed the application that he was turned down, we came in and he sat across the table from me and said, I've been thinking about strangling you, but I think you're on my side. And I said, yes, I am. Now, that was at a time when we knew we were going to be 2 more years before we would have a hearing. We got to the hearing and the ALJ said, why is this case here? Why was this man not approved at the initial level? Of course, that's sort of what I thought also. I had a client who was homeless, which meant that she qualified for lots of services at the VA hospital here, including a social worker who would take her places. She was in the Navy and was assigned to a ship for a year, was raped 4 times, was receiving child support from a superior officer when she came to see us. And just almost could not testify at the hearing, not because she was afraid of the judge or the hearing process, it's just that sometimes she could hardly speak at all. One client, PTSD was interesting because it was not from sexual trauma, but she had been a diver and she had been in water that had all kinds of chemicals repeatedly. Diving in that, then had some illnesses clearly related to the diving, and the PTSD resulted from that. I am old enough that I've done lots of clients who had been in Vietnam, and one man I can remember worked at a brickyard and was tormented by his co-workers who thought it was funny to make loud sounds and he would hit the ground. And told me of one incident when his grandchildren were there and he had a little cabin and they were supposed to be in a tent, but he had told them, don't come over here. Well, they did come over in the middle of the night, and of course his reaction is, there's a noise, I pull a gun. And he was really scared about what could have happened. I represented someone who had been a security guard for almost 30 years at the Department of Corrections and had gotten along on that job fine until all of a sudden it just hit him and he was totally incapacitated by his PTSD. A therapist told me, and this is why I think this part of the program is important about having to ask this question. The therapist said, she had said to her patient, how was your childhood? I guess that's a standard phrase that she uses. And the person said, oh, it was normal. She said, 2 minutes later, we were talking about all this sexual abuse. How could she say to me, oh, it was normal. You don't ask specific questions, you're probably not going to get answers. I talked on this in Chicago a couple of years ago, and during the questioning, these were all lawyers, one person said, well, we represent a lot of people with AIDS, and we don't have to prove why they have AIDS. And as all of you know, your best comment is about 24 hours later when you think of what you should have said. And I should have said to her, you have a blood test. I don't have a blood test. I have this woman's word about what happened and what she does every day and what she feels like. And maybe I have a psychiatrist or psychologist who confirms that. And they also frequently don't go into enough detail, which causes problems for us. I was at a meeting in San Diego, national meeting of the National Alliance on Mental Illness. I think it was 2007, but I was walking into a meeting about veterans issues, and someone introduced himself as the representatives from the Veterans Administration in New York. And I said, I think where I live in Columbia, we get good care for our veterans. It's just that it's not enough. They need more. His response was, this was in 2007, so how long had we been in the Middle East then? Oh, we don't see much PTSD from that. It's really still mostly from Vietnam. I thought, well, where has he been? Why do I see it in Columbia? And I read about it in the paper, but this person doesn't seem to think that it exists. A major problem for us with Social Security is the Veterans Administration hospital and trying to get help, because my understanding is they have a regulation that says they're supposed to help veterans with their benefits. I think we've talked about that. But also one that says they're not obligated to give an opinion about disability in any other kind of case. Well, Social Security doesn't like for physicians to ever have opinions about disability. I had one physician that I finally took the federal court opinion to him and had his name on it, saying, well, he used the word disability, so we're not going to pay any attention to it. But the chances of us getting someone at the hospital who is treating the person, because treating sources have much more weight, to fill out a small form or write a narrative report are, I would say, about 2%. I tried to get around that once by writing a letter to somebody that I knew at home, and she sort of went through the system, and I think the final result was thrown in the trash, because I wanted to at least come over and talk about what they could do. These are people that are seriously traumatized, and most of them have already been found disabled by the VA. They've paid in the Social Security benefits. They have to get the treatment at the VA hospital because they don't have funds to go somewhere else. If we can get them on disability, then they'll get Medicare in a couple of years. But there is somehow a feeling that that is not an important thing. And I think the caregivers think, I'm trying to take care of people. I'm not trying to get involved in, I guess, what they think is a legal dispute. But you're taking my time away from taking care of my patients to fill out this form. And that particular system, we can't offer to pay them. They're not going to be paid by us or the patient or anybody else. Someone used the word in a question, it was a nothing. And the major also talked about the case where there was no, decision was, well, there was no penetration. One of the things, the books I would recommend to you, and I will provide a bibliography that can be used on the website, but it's called The Trauma Myth. It's by Susan Clancy. And I meant to bring that today because she says when she started her PhD in psychology, at Harvard, one of these professors of psychiatry said, don't get into sexual trauma. It's just too political, it's too emotional. Emotions always win out over facts. Stay away from it, which she ignored that advice. But she set out to prove that mental trauma is worse when it depends exactly on how much physical trauma there was. She said everybody knows that, so I'm just going to prove it. Well, of course, it turned out to be not true at all. The people for her study came from people answering an ad in the Boston Globe, which started with phone calls at 5 a.m. But what she says is, particularly when you have a small child who doesn't know what's going on, there may not be any physical pain. And the child doesn't understand what's going on, and then later, as an adult, they feel guilty, and they say, well, why did this happen? What did I do to cause this? And I should have done something then. And the trauma is just as bad or worse than it is for somebody grabbed on the street and raped. You cannot make the comparison, and the person that it didn't happen to is not in a position to say, well, your trauma is pretty serious because you had a lot of physical pain, but yours isn't, and you should get over it. But I think her book really provided as much information to me as I could have had. And one decision I got from an ALJ in Missouri, not in Columbia, one of the lines said, well, she has this whole story about sexual abuse, but obviously that's not a big deal because she works as a prostitute. Now, how long do you think it takes to use Google and find out how many prostitutes were sexually abused as a child? It's about 30 seconds. And it's about 96%. And that, unfortunately, I did not get to take to court. She moved to Louisiana, and I couldn't get local counsel. One of the big issues is the reluctance of the caregivers. By that I mean psychiatrists, psychologists, social workers. Social Security, its psychologists and psychiatrists are acceptable medical evidence. Everybody else is something else. So advanced practice nurse, clinical social worker, you're something else. But the reluctance to talk about this. And I would see records where it says he was abused by his next door neighbor for the entire 6th grade. And it's never mentioned again. And I ask, and so of course sometimes people don't put everything in the notes, but I ask the client, well, did you talk about this? No. They never asked me about it again. I asked one therapist who said, well, it's a very unpleasant topic. I said, well, I understand that, but isn't that what you people are trained to do? I asked, actually it was a dean on campus here who said, well, I think what happens is they think I'm not qualified to treat this, and I don't really have somebody to send them to, so it's better not to get into it. And I mentioned that to a pediatrician who said, well, I'll tell you what, we don't have the luxury of saying, well, I don't think we'll get into that. We've got to deal with it that second. One of the handouts that I have, which is out here and will also be on the website, is just questions. And I was glad to hear Judge Bradley talking about Walmart, because that's always one of our questions. But these are questions that we often ask, and I have listed answers. Now, I did this about 2008. I had to go back and add one from last week, which was, I know he has a problem with his hand. Does that interfere with brushing your hair, brushing your teeth? And the response was, well, I haven't brushed my teeth in years. I had not gotten that answer before, so I had to add that. But all these are answers that I have gotten from clients. I think the hard thing is you have to be able to say to the person, were you sexually abused as a child or a teenager or as an adult? You leave one of those out and you make it a no, and it's really a yes. Now, it would be nice to do that on the third or fourth appointment. For us, it depends on when they come to see us, and we may have only one appointment before the hearing. We usually ask the other questions first, but it's a little like there's a course for high school and college students about suicide prevention, and that is if you have to be able to say to your friend, are you thinking about harming yourself? And then the other part of that is if you say, I just can't say that, then you go get somebody who can. But you can't just walk away from it. I think with clients where we know there is sexual trauma, the risk for the attorney by saying, well, we'll keep our fingers crossed, maybe that won't come up, that's not a risk you want to take because you have no idea what your client will say. I will mention just a couple of things that I think are representative, and then what happens to those people. And this one I think is most interesting because this is someone who is sexually abused by her father, was put in foster care. I have had people say, when I ask, were you abused in foster care? Yes, in every home. But was unable to use her left hand, as her treating physician said, because she had cut it when she was 17 and really couldn't use all the fingers. Had a hip that the physician said would pop out as she was moving on the examining table. Terrible breast cancer issue, which had been cured with quotation marks. Terrible psychological issues. That case we lost at the hearing, and we lost in federal court. But things that we will hear regularly are, you bathe regularly? Well, once every other day, or once a week. What's the longest you've gone? Well, a month. And I had to learn on my own, if the immediate answer is, oh yes, to then say, well, do you bathe or shower more than once a day? Because then invariably the answer is, well, yes, 2 or 3 times. I never feel clean. And you know where that's going. Concentration is difficult, can't read a newspaper, can't watch TV, cry once a day, don't want to go to Walmart, don't want to see people that I know. One person had been fired from every job she had. We've been litigating that case for 5 years. Fired from every job she had because she would get mad at the manager. And her trauma was not quite as sexual, but she would act out in the first grade, and the teacher would lock her in the bathroom. That was the solution. And then you add to that the other traumas, and it was difficult. We take a statement from the client, and I'm going to try to get to that quickly. Well, I'll just tell you what we do. To ask the client about it's not just sexual abuse, but to really go into detail about their daily activities. Put that in a statement that we can provide to Social Security that will have these things like crying daily, irregular bathing, inability to concentrate. So we're clear on that, and I think it makes it, and we attach it to, in this case, the VA case, that particular form, so the judge has that ahead of time and can see what is involved in this. And I'll close with one that we've just lost, and we're working on the appeal. And the issue is, the ALJ says this woman has lied. I asked my associate to go through, and I said, tab all these places where the judge mentions lying. It's like 9 times. They're pretty confirmed. Now, does it make a difference if she was sexually abused by her father from infancy to age 17? She's 58 now. Is her outlook on life different? Is she going to react differently? Is she going to lie about some of these things to try to get help? I think obviously yes. Now, I have to find an expert that can talk about that. But I will be around. I'm always glad to talk about this. You can always feel free to call me. Thank you.
Jim, I wanted to make sure there was time. And Judge Bradley, if you could tell us, if someone wants to be a mentor in Veterans Court, what requirements do you have to have, and is there training available for mentors?
Yes, there is training available. Unfortunately, right now we're in the process of changing mentor coordinators. We started off with a really great mentor coordinator who was a Iraq War veteran, young lady going to the university. She graduated, got a full-time job. Then we were fortunate to get a mentor to act as mentor coordinator. Now we're going to go to our third one. But we have the applications there, or you could get a hold of me or Clayton Van Nustel. He is our coordinator for the court. But we have our applications. You have to fill out the applications. We do a background check on everybody. The coordinators the mentors are very great and helpful, but they are also my biggest worry. I mean, I just worry about these all the time because I don't want any of the participants to be taken advantage of by the volunteer mentor, and I don't want the volunteer mentors to be taken advantage of by the participants, and you have to really watch that. So far we've been very lucky on that. We haven't had any problems. But if they want to sign up, we sign them up. We will do a criminal background check. We do give them some training. The basic training is you're not a counselor, you're not a mental health professional. That's not what we're looking for. We're looking for somebody who's a fellow veteran who can relate to the person and can just be kind of a friend for them.
So you have to have a military background.
Have to be a veteran. That's the whole point.
Very good. Any questions for this panel? Ryan, what does Welcome Home need? That's a softball.
That's a really good question, actually. Okay, well, actually, our president at Welcome Home just stepped out, but at Welcome Home, we've just began an endeavor with Columbia Housing Authority. We both teamed up for, we bought a site, and we're getting ready to kick off a capital campaign to develop a new facility. Out on Business Loop 70, it was the Deluxe Inn at one time, kind of a 1950s, 60s, maybe 70s hotel. There was a big heart-shaped hot tub in one of the rooms that we're going to auction off at an event. So be prepared. So that's going to be out there. But our main
That would look real good right here in the front.
Right, a great addition to Holston. Really spice things up around here. So with that, our largest concern is on the Welcome Home side, we've taken over transitional housing. So our priority, our main focus is to get the veterans in, identify the issues that they're having, whether they be underlying or just obscure things that are difficult for them to get to. We identify these issues. We try to seek to get their benefits that they're entitled to, try to find employment for them, try to get them back into a position where they can continue being living a meaningful life, being a productive citizen. And Columbia Housing Authority is going to take over the permanent housing side. So there will be two different entities on this same site. We're taking a proactive instead of a reactive stance here, largely because we're going to experience an unprecedented number of female veterans returning from combat. World War II, Vietnam, Korea, we've never had this number of females. And with these ladies coming in, these lady warriors coming in, they have their own very specific needs that have to be tended to. Unfortunately, right now, we're turning away about 5 to 6 female veterans each month because we simply can't house them. Obviously, I think it would go without too much elaboration to identify that it would be a problem to place a female in a home with, potential military sexual trauma issues, along with 10 of her male counterparts, or 11. They're also, they found themselves there in dire circumstances. So we're really trying to get on top of this ball, so after this influx of female veterans hits us, we're not scrambling to make a move then. The VA tells us traditionally 10 to 15 years after someone has ended their service in that theater is when we experience the homelessness and all these other things that are a product of that experience. And we're getting people sooner than what we technically should, or statistically should be anticipating. So if you could follow the developments of Welcome Home, I would greatly appreciate it. I'm very easy to contact. I didn't bring any cards here today, but I work for Angela in the legal clinic. If there's any questions you have, anything I can do for you, anything you need me, please feel free to contact me.
It's tax deductible, right? Check.
We are 501c3, so if you need this money, we were looking for it.
Thank you,
Thank
Brian.
y'all.
And Tim, thank you for your work in the Social Security area. It often lays the groundwork for our veterans cases, so we appreciate all your tips. We have a guest who drove here from St. Louis and wanted to share some things with us. It's Mr. Fred Fogey, who's President Emeritus of the Missouri Gateway Chapter, 101st Airborne. It's a special pleasure to me because my father served in the 101st Airborne in Vietnam. So I was thrilled to see the Screaming Eagle as I walked the house home this morning. Thank you. Thank you very much for being here. Yes. Okay.
Good morning. Good morning. Well, I'm probably the oldest eagle in the house. I go back a long ways with this division. I came up with it in 1959. And it's a remarkable division. Would you believe that we started with General Grant, 101, 1861. That's a long time that the Screaming Eagle been around. Some of us do not know this history, but I want to give you this.
Well, thank you very much.
Cut down some of my minutes.
I will post it on our bulletin board.
I want to thank this learning institution. I'm so proud to be able to be invited to come here. Not only did I have a director of my organization, Mr. Ferret, and also I have Sean Lee, who's attending this fine university. I am a little jealous. I go back to the University of Maryland in the days we had wooden domes, so we won't talk about that. But let me give you a brief history. The 101st was activated years ago to fight in a war called World War II. And our first commander was General Maxwell D. Taylor. And we put a bunch of guys together with the 82nd Airborne and the 101st, trained all over the place, and then this fine unit went to Europe. And they marched in a place called England. From that point, D-Day, the unit jumped in Normandy. Most of you might have saw some of the D-Day flyers out. We are involved with D-Day. Each and every year I be sitting on Jefferson Barracks commemorating a wreath for the 506 Band of Brothers until it is totally recognized by this state and by the 101st itself. We'll talk about that on another day.
We may have a special day just for you to come. Sure.
Okay.
101st are paratroopers, for those who are not familiar.
Oh yeah, let's get back to that.
Yeah, they jump out of airplanes.
The 101st is a history that I'm so proud of. I was a young man, about the age of 19. At that time, I was a bristling young sergeant. You don't find many at 19 years old. And I was about 140 pounds, soaking wet, and the meanest thing you ever want to see. But at the age of 19, I guess I was beyond my years to come. I had graduated from school, from college at 19. And I am not a lawyer, but I'm a construction engineer draftsman. So as the Army do, like most of the JAG officers, you get to be placed in the right position. When I went into service, they put me in the infantry. So, 101st opened up. I was with the unit called 187 Airborne, and we left Japan in the old days. Went to Fort Bragg, North Carolina, and then into Fort Campbell, Kentucky. Now, this is how it all started. They needed a draftsman, so they enlisted me. So I sit behind the drafting table, and this young colonel who fought in World War II came in, is Colonel George I. Forsyth. His son is the president of the Fulton College down the road, Barney. Most of you probably heard of Barney Forsyth. I used to babysit him. He grows to become a one-star general. Anyway, what happened to this patch? You see that I proudly wear. They wanted a new patch. The first patch that ever came through looked like an eagle. And Colonel Forsyth came to my office and he said, Brett Fogey, he said, how you like this World War II patch? And that was very honest. I told the truth. I never would lie about nothing. That used to get me in a lot of trouble too, so I wouldn't lie. But I told him it looks like a parrot. So, it was a parrot. And I changed the way it looked. The way you see this patch is, I changed it. So I'm the guy that redid the 101st Airborne chapter. I want to present this university to this fine professor here.
Oh, thank you.
A copy of a memoir that was written about this old soldier.
Well, thank you. That is very
It
special.
tells this story about my life at the 101st. And then once we put this thing in place, I moved on and I fought all over the world, and I never went to combat with the 101st. I fought with everybody else in Vietnam except the 101st. General Forsyth, he wouldn't bring me to the Air Cav Division. I wrote him a personal letter. I had a company up in the 5th Mech up north in Vietnam, and he wouldn't send for me. I said, Joe, I said, I would like to come in your command, the 1st Cav. And he said, well, if I bring you here, which I found out later, Dorothy would probably kill me if I mess around and get you killed. So I never went there. But anyway, I want to tell all of you involved with this PTSD, it's serious business. And as far as I can see, this university is doing more in this county, in the state of Missouri, than anybody I've ever seen so far. Stays on top with it. And last I spoke with Senator Clara McCaskill about 2, maybe 4 or 5 months ago. And I've been arguing this same point about the PTSD,
Right.
the MST. So y'all keep up the good work.
Thank
today.
you. There it is, the Screaming Eagle.
This
Back
belongs to
there.
the
Yeah.
children.
website. We are so lucky that Lieutenant General Harding and his wife have moved to Columbia. He is a force of nature. He's an incredible speaker. He started a program for victims that he's going to tell you about that became federal law. Now every service is mandated to use that program. He has advised our nation's leaders on some of the most sensitive topics that you can ever imagine as the Judge Advocate General of the United States Air Force. So please welcome Lieutenant General Richard Harding. Thank you so much.
That's a tough act to follow. You know, if you're going to follow somebody, a screaming eagle from that time frame is probably not the person. Hoorah, that's right. If y'all ever have the opportunity to go to Bastogne, the trench line is still there outside the town of Foy, and the foxholes are still there. And it's kind of a spooky place to go. Hey, listen, I first want to just kind of compliment you on the choices you have made. You have made a choice to serve those who serve. And I can't think of a more just cause or a more honorable way to serve as an attorney. You know, it's kind of difficult as an attorney to get a chance to choose your own client. Well, here's an opportunity. I stayed in the Air Force 34 plus years because I got to choose my client. Not every attorney gets to do that. So those of you in the room that are doing that today, think about that as a long-term kind of endeavor. In my last job as a Judge Advocate General, I had about 4,400 attorneys and paralegals worldwide. And we did everything under the sun. Defense of civil litigation, criminal actions, environmental law, labor law, employment law, if you will, space law. But we had 4 areas where we represented airmen. One was our traditional legal assistance program, which, by the way, is a creature of statute. 10 U.S.C. is armed forces. Deals with armed forces. 10 U.S.C. 1044 deals with the legal assistance program, and it says specifically the scope is limited to private civil legal affairs. Civil legal affairs. By service regulation, it would exclude filing claims against the government, to include MST claims or any other VA claims. That's one program. We've got another program that deals with defense counsels, and I had 106 defense counsels. My background, I had been a defense counsel at one point. These people do, in Harding's humble estimation, God's work. They're great. They represent airmen that are accused of creating or having violated the UCMJ, the Uniform Code of Military Justice, in some fashion. We have a third set that deal with the IDES, Integrated Disability Evaluation System program. These are people whose clients are being separated involuntarily from the Air Force because of some kind of disability. Now, this is in conjunction with the VA process, but if it is known at the time while they're on active duty that they are no longer worldwide qualified because of lots of different reasons. Some of them are OEF and OIF, Iraq and Afghanistan wounded and are being separated with disability payments. Some are people that just kind of got a bit of bad luck in life and develop something that won't allow them to serve any longer on active duty. For example, sleep apnea. They've got to wear a mask at night. It's difficult to go to Afghanistan where the electricity is not reliable and have to wear a mask at night. You're no longer worldwide qualified. So we've got 9 attorneys that are working there. When I first took that office, there were 3. We plussed them up to 12. They said 12 is too many, so they went down to 9. You know, last year they did an incredible amount of work. They counseled over 2,000 Air Force members, and they go through a series of administrative levels in the IDES program. So we start with a medical evaluation board. It goes to a physical evaluation board, an informal one, then a formal one where literally the airman can make a presentation. At the formal one, they had 700 hearings last year alone, those 9 attorneys. So you can imagine they're doing a couple of hearings a week. It's a fly-by-your-seat kind of litigation. They love it, and they're doing great work. We've got an equal number of paralegals that team up with them. So that's the third set. I want to talk to you today about the fourth set, Special Victims Counsel. This is kind of something new. It's a new animal, frankly, in the United States. My background before I was promoted to the level I ended with, for the first 15, 20 years, I, in some fashion, litigated cases. Most of my time was as a prosecutor, but I also spent time, I've had time as a defense counsel where I represented people that were trying to go through the very processes that we're talking about today. So my time as a prosecutor, I wound up spending a lot of time with victims. And it's difficult when you're a prosecutor and you've got a victim because you really represent the people. In my case, the United States. You don't represent this victim, although the interests seem to collide, be parallel, because both of us want to affect a prosecution. At some point, sometimes they diverge. And it's a difficult conversation to have with the victim early on where you have to say, you know what, I don't represent you. You and I share the same object, the same goal, but at some point, we may see this differently, particularly if you have an offer for plea negotiation. And I, as the counsel, think that's a wise thing to do. Let's take the negotiated plea. But the victim says, oh no, I want to see some kind of death penalty result here. Why? Because they're understandably caught up in the emotion of it. But you as the attorney have to maintain that kind of cool exterior, dispassionate, and try to figure out what's in the best interest of the people, your client. So when the Air Force and the other services started to go through examination, first by the media and then by Congress, about how many sexual assault cases we had, my boss, the 4-star that runs the Air Force, it was about Veterans Day about 3 years ago, sat down a couple of people that had critical roles in responding to sexual assault and said, what can we do differently? I don't want to do more of what we're doing today because we're doing a lot of that, and I'm not sure it's getting us in a happy place. So what can we do differently? And having worked on cases with sexual assault counsel before, private counsel, I said, sir, one of the things you could do is you could give victims counsel. There's a difference between giving victims information, and the VA is very good with that. Here's an information packet, here's what you need to put in your claim, and providing advocacy. A huge difference. He said, what would that do? I said it would do several things. First, it would build first, it's the right thing to do. We all recognize that. Why? Because these victims are our people. They're not strangers to us. They're other airmen. So it's the right thing to do, number one, which is a good place to start from. Number two, we have an absence of trust and confidence in the Air Force, Army, Navy, and Marines about the processes we have that are there, frankly, to take care of victims. Victims don't see it that way. They oftentimes see those processes as a re-victimization, a re-traumatization. Why? Because those processes are difficult to understand. They're lengthy. You got to go to law school to understand a lot of these. Anybody in the room ever explain rape shield to a victim? Services thought it'd be a good idea to have victim advocates, not attorneys, sit down and explain to a victim what the rape shield rule of evidence allows. Rape shield says prior sexual liaisons aren't relevant, right? In a criminal case, with 3 important exceptions in most jurisdictions. The last one of which is when that evidence is required or compelled constitutionally. All right, now who in the room wants to explain the circumstances under which the Constitution would require admission of a previous sexual liaison? It's a difficult thing to do. The only way to do it is to do it from a position of experience. And here's how a special victims counsel does it, because they're all experienced. You know what? It's situational. You kind of know it when you see it. I've seen these things before. Let me worry about that. You worry about something else. And the weight of the world is lifted from their shoulders. And that feeling of being re-victimized by a process that really doesn't have your best interest in mind starts to fade away. So those were the reasons. We thought it would be a good idea to go ahead and engage in this. It's kind of spooky because you don't know where this is going to go. The reason you don't know where this is going to go is because all of our surveys show that only about 13% of our sexual assault victims actually report. And there are two ways to report. You can report unrestricted, I'm willing to participate in prosecution, or restricted, I need social services, I need medical services, but I don't want to participate in a prosecution. 87% never say anything to their commander, to their supervisor, to anybody, other than perhaps their best friend. And those are normally our first responders. We found that out pretty quickly. It's the people in the barracks and the dormitories that are the first responders. So how do you get your arms around a problem that you can only deal with 13% of it? Why do we have such large numbers for sexual assault in the armed forces? Frankly, why do they have them in universities today? By the way, those are the same percentages that the president quoted when he talked about universities a couple of months ago. Why? Why do we have those numbers? It's because 87% of the time, the perpetrator gets away with it. Report is never made. So how do you encourage reporting? One way to do it is to embolden those victims, those survivors. You tell them, you got somebody on your side. Yeah, the prosecution represents the people. This defense counsel, remember that other community I talked about, represents the accused, but here's somebody that represents only one person, and that's you. And they do so zealously. That's their ethical obligation. We started the program 2 years ago. Last year, we finished our first full year. Reporting of sexual assaults went up 30% in the Air Force in 1 year. Was that because we had more airmen assaulted? Likely not. It's that 87% coming forward. So we expect even more. That's why this is scary. If we had 13% when we started, where are we going to end? And if we're successful, we get 100% that report. And now we've got to provide them representation. So we have 30 counsel in the Air Force that are doing this right now. I wouldn't be surprised to see that we have 60, 2-3 years from now, doing the very same thing. The Air Force started it as a pilot program. In all candor, I will tell you it was not widely applauded. That's an understatement, anywhere, even in my own service. When we talked about this inside the Air Force, the response was, oh my goodness, it's game over. That was one response from one of my senior folks. Another one said this idea represents everything that all our enemies that we fought since the end of the Cold War have represented, which really confused me because I wasn't aware that the Taliban had Special Victims Counsel. Somebody screamed out, where are they going to sit in the courtroom? Where are you going to put them? Well, I'm going to put them back there in the galley with the rest of the spectators. It's an open process. There's no table. Well, do they have standing? Well, no, they don't have standing. What we discovered were there are 3 rules of evidence that allow a victim to be heard, give a victim the right to be heard. And we advocated and won on appeal the idea that to the extent that the victim has a right to be heard, the victim has a right to be heard through counsel. And the Court of Appeals for the Armed Forces concluded that to be the case. That was a sentinel case that's now being used by civilian jurisdictions to stand for the same proposition. The numbers are scary. In 2012, we had a little under 4,000 wounded in Afghanistan. 2012, our survey shows we had 26,000 sexual assaults in the Department of Defense. All right, now figure out what happens when those 87% begin to disclose what happened to them. Sometimes it's after they leave the service. So the ratio there is 8-to-1. So what are the chances that this thing is going to go away in terms of airmen, soldiers, sailors, and Marines, ex-airmen, soldiers, sailors, and Marines, filing claims for MST? It's only going to get larger if we're successful. And I think we are going to be successful. So my boss said, you start it, and we did. And from there, he advocated that the other services might consider looking at it as well. We held 7 meetings. The vote was always the same, 4-to-1 against, the Coast Guard being one of the voting members. The Secretary of Defense said, okay, understand everybody's concerns. We're going to do it anyway, and ordered it to be done throughout the Department of Defense. And then Congress quickly, about 3 or 4 weeks later, included it in the National Defense Authorization Act for FY14. So now it's by operational law included as a right of airmen. They do not only, by Congress's scope of the legislation, not only defend the interest of the victim in a criminal law setting, but they also get restraining orders, no contact orders, expedited transfers for their clients. I don't want to be next to my abuser any longer. Could you send me to another base? They help, and they are required by act of Congress now to assist in the filing of MST claims with the VA. The problem is this. When Congress amended that statute, it amended a statute, our legal assistance statute, which again is limited by scope to private civil legal matters. Is an MST claim against the VA a private civil legal matter? More importantly, and I would suggest yes it is, but more importantly, that same statute limits that provision of legal assistance to active duty, retired, and family members. Well, if you're just separated, you're none of the above. So we're going to have to pass that client off to someone else. And that'll be y'all, unless the law changes. I'll give you two things to think about, and then I'm going to get off the stage here. We, the Department of Defense, has demonstrated that Special Victims Counsel can work in our environment. There are other environments where it can work in as well. One of those environments is the VA environment. VA has a separate series of statutes. It provides, again, information, and it does so very well, but doesn't provide advocacy at the cost of the VA for those people filing claims. Think about that. Think about why it doesn't, and perhaps it should. Bob McDonald, their new secretary, announced yesterday his customer-oriented approach to providing services for the customer, the VA, the veteran. Well, on active duty, we can provide this, and it works well. Why wouldn't it work well outside of active duty as part of a VA benefit? Now, I'll even suggest even beyond that, you've heard a lot of dialogue about sexual assault in the university level. Now, how different are those victims from the ones that are on active duty today? And I'd suggest to you there's no difference. They're 18 to 25 years old. They made a choice after they graduated from high school. One went to the service, one went to a university. Oh, by the way, a lot of those that went to the service are going to take their post-9/11 GI Bill and go into the university. They were just that smart when they made that election. So if by law we give sexual assault counsel to airmen, soldiers, sailors, and Marines, what would prevent us or what should stop us from doing the same for university students? In other words, which one do we care more for, the veteran or the student? Or should we ever have to make that choice? They're all America's sons and daughters, pure and simple. So just food for thought and where this may go in the future. You know, it'd be great if we could have organic counsel in the Veterans Administration. It'd be great if we had organic counsel for victims of sexual assault at the university level as well. All right, well, that's what I had to present today. I hope I gave you something to think about and a little bit of an explanation of where we've gone in the last couple of years. Thanks, Angel. You bet.
Symposium. Thank you, General. What a remarkable way to end. Everybody be smart, be prepared, make change. Thank you for that. There is a wreath-laying ceremony at Memorial Hall that the speakers and I are going to walk over to. Everybody is invited to join us if your schedules allow. Thank you again, everybody.
Thank you, Angela.
Some of them are dangerously